Good night. Is my mic working?
Yes.
Okay, thank you.
Good evening.
Good evening.
Good evening, everyone.
Good evening.
Miss Archer.
Who had volunteered to do a presentation on mortgage versus renting? I didn't put a name, but I know someone had volunteered. Who was that lucky person? Anyone can recall? Remember
The topic doesn't sound familiar. Mortgage
Yes.
versus renting?
Yeah, someone said they had done a presentation at work. And I said that would be quite interesting.
Oh,
Yeah, who was that? I didn't put a name. I put a note here. But I didn't put a name. Somebody. Yeah,
wasn't Krista?
no, it wasn't Krista.
Oh, it was not.
No,
No, it was not.
Krista.
That's fine.
Let's do some housekeeping now. Look at your schedule. So we didn't do unit 5 last time, remember? So we're gonna do unit 5 today. We'll do unit 6 next week. Unit 7 the following week. And then on March 20th, we'll do practical examination of legal documents and customer due diligence together. Because I think customer due diligence, everybody's familiar with that. Sounds okay?
Trying to write this down. Okay.
Yeah, Miss Archie, you could
That's fine.
skim
So
that
let's
one
go
more
again.
time.
Okay, let's go again. Where you have mortgages, duties, and liabilities, that's for today, February 27th. The mortgagees, duties, and liabilities, March the 6th. Understanding the mortgage process, plus the presentation, will be March the 13th. And then practical examination of legal documents and customer due diligence, both will be done on March 20th. Say it again, or everybody got it?
Can you repeat it one more time, please?
Okay, so mortgagors' duties and liabilities that was scheduled for February 13th will now be today, the 27th. The mortgagees' duties will be March the 6th. Understanding the mortgage process will be March the 13th. And practical examination of legal documents and customer due diligence together will be March the 20th. So the exam date, none of that has changed. We're just pushing them together.
Good evening, everybody. Ms. Archer, could you repeat that, please? Because I just came on.
Today's class will be Unit 5. The mortgagors' duties and liabilities. So put the date as February the 27th. The mortgagees' duties and liabilities will be next week, March 6th. Understanding the mortgage process, plus the presentation that was promised, March 13th. And then the practical examination of legal documents and customer due diligence will be March 20th.
Ms. Archer, sorry for my lateness to the class. My
That's
area
fine.
has internet problems. I have to join from my phone.
Oh, okay.
Okay.
You were the one who volunteered
Volunteer to do.
to do the presentation on mortgages versus renting.
No, but I thought you assigned us different cases.
No, I talking about the first class when we were doing the introductions. Someone
On-
said they had done a presentation at work. And then I told
Oh.
them, I said, okay, it would be nice if they could do it for the class.
Oh, I thought that was Krista.
No, it was not.
Oh,
Y'all
Santina.
trying to set me up?
Good one.
Santina.
Ah, there it is. So Santina presentation will be, because she isn't on, so you need
Okay.
to let her know. Her presentation will be on March the 13th. When we talk about understanding the mortgage process, she can do her presentation then.
Okay.
So let me put her name right here.
Sorry, Krista.
That's all right.
Krista, they trying to throw everything on you.
Everything, the whole house.
Sounds familiar, hey. It sounds familiar, hey, Krista. Every class.
It does. It really does.
Yes. They throw everything on her. Everything. All right, so everybody had a chance to review their cases?
Sorry, Ms. Archer, 1 second. Shantina couldn't make it to the class, but I just messaged her. She said, no, she didn't volunteer. She said she
Yes,
doesn't
she
remember
did.
who it was.
Ah, you all are too jokey. But anyhow, you all have 2 weeks to decide who did the presentation at work and who volunteered. Why didn't I write that name down? Trying to crook me.
You're slipping, Miss Archie, you're slipping.
Yes, I should not. I just said, you know, these ladies, they know what they're talking about. They'll come forward.
You know by this time in the class, in the middle of the class,
They
after the
were boasting.
midterm.
No, they were saying how well the presentation was received and it was a good one. So I said, share it with the class. And they said, no problem.
The more you talk about it, the more I remember
do,
that conversation, but I
yes.
don't remember who.
Exactly, I remember. Who's missing from the call? Who hasn't joined us yet?
Let's
It's
see.
probably somebody who isn't on as yet.
Probably. Is Katora on? Was it her?
No, it wasn't me.
You on?
Yes, I
Oh.
am.
Hold on. I'm on my actual computer, not on my phone. Okay, I can see you now on the end. Oh, you sure jump up quick and say not you. Let's see.
I think that was someone from, do you have someone here from Fidelity or,
Yes, from Fidelity is Shantino.
okay, never mind.
So who could that be? There's somebody. Who? Somebody there. Got to be from BOB then.
I feel like it's
It
from
wasn't, it
BOB.
wasn't a BOB. It
I
wasn't
think
a
it's a
BOB
BOB.
person.
And
It
yeah,
wasn't
it's
a
a
BOB.
BOB.
A BOB person.
We have the
No,
recordings, right?
It wasn't me.
Yes, the
wasn't me.
recordings, Katura.
The
The
recordings, yeah,
recordings.
and that's where I heard it because I was not present for the full first class. But when I watched the recording, when I listened to it, I heard what you that same conversation you were talking about. But I
You
just don't
see?
remember who the person was.
got
It
them on
wasn't a
tape.
BOB person.
But you could hear the voice. So you all have to go back and listen to the first recording, and that's the voice.
I know that when our very first class, when we did introductions, Shantina, when she introduced herself, she was talking about something she did. Now, I'm not sure if it was the renting versus what is it? Renting
Mortgage?
versus a mortgage. But when she was talking about herself, she said something about a presentation that she did, and you told her at some point you would like for her. So
Yeah.
maybe it's the
I
topic
wonder,
that's
that's
throwing her
Shantina.
off. So she's saying it's not that topic, so maybe the topic is throwing her off.
It's rent versus home ownership.
I think the topic is showing off too, Stacey. You're right.
Yeah, but she knows what it is. Tell her to ring a bell.
Okay, I'll remind her.
My scribble note says mastering mortgage student to present rent versus home ownership. And then my next little reminder was a thing for Krista in Jamaica that I sent to her already. So, no, Krista, I remember. I don't forget.
I know, I got it. Thank you.
I don't forget. So if it is her, what she says, no, her, tell her check the recordings.
Okay, will do.
It's her. Can't renege now. She's done it before, so she all she has to do is present it. So how many people read module 5?
I read it.
Read it.
Oh, wonderful. So can we focus on the cases then? Or we have to go through the notes. Any questions on the notes?
I didn't have any questions.
Okay. So let's start with Peace Holdings. Where's my notes? Who's supposed to
That's
be-
me.
Okay, which one did I send? Court of Appeal, right?
I'm sorry?
Court of Appeal?
No, First Peace Holding Limited. Excuse me, because I'm not feeling too well, but
Yeah, I know. That's
Peace
why.
Holding Limited versus First Caribbean.
Yes. Go
Okay.
ahead.
The findings with Peace Holding Limited, appellant, and First Caribbean respondent. The date of the appeal was the 14th of April, 24th of June, 14th of July, 18th of September, 2014. It was a civil appeal, leave to appeal, interlocutory order, final order, whether to leave appeal required from a trial judge. In 2006, the respondent loaned the appellant a large sum of money to develop a condominium on Paradise Island. The loan was called in in 2012 and receivers appointed to initiate the sales proceeding. The appellant alleged that the debenture was invalid and unenforceable and sued to stop the sale of property. The order held the preliminary point dismiss, cost reserve, and conclusion of appeal. The order for sale in the present case disposes of any question of respondent's right to sell under the debenture. In any event, if the order was not given, the respondent would still have the contractual power to sell the property secured by the debenture. In either case, the mortgage action is disposed. The order of the trial judge then is then the final order and thereof appeal as of rights. The need to obtain leave to appeal from the trial judge does not arise. The decision delivered by the Honorable Justice Allen before the court, she said, a note of appeal was filed on the 12th of March, 2014 by the appellant, by which the appellant challenged a judge of Isaacs J, given on the 27th, 2014. A notice of motion, these are what were presented to the court. A notice of motion by the respondent filed on the 20th of March, 2014, applying to strike out the 12th of March, 2014. Notice on appeal on the ground that an interlocutory judgment required leave of the court below or the Court of Appeal pursuant to Section 11 of the Court of Appeal Act, which was not obtained. So they're saying that, simply saying that he did not have enough grounds to, the case was actually a temporary decision. It wasn't a final decision. I know, I think, right, Ms. Archer, I think something like that. Interlocutory lock means that it's not final. It's a temporary decision that's not being made on the issue. A notice of intention filed on the 29th of May 2014 by the respondent to rely on the preliminary objection that grounds 2, 3, 4, and 10 of the notice of appeals were relative to an interlocutory decision which could not be appealed without the leave of the Supreme Court or the Court of Appeal. At the end of the hearing on 14th of July 2014, we reserved our decision. By way of the background, the respondent loaned the appellant some $30 million exclusive of interest. The loan comprises of 6 separate advances beginning in 2006 for the purpose of developing land at Ocean Place, a condominium development. The appellant defaulted on the loan. The development remains unfinished and the loan remains unpaid. The respondent called in the loan on the 18th of October 2012, given 30 days for repayment, and agreed to extend the facilities for a further 6 months if $3 million was injected by the appellant. That did not happen, and the respondent appointed a receiver on the 19th of November 2012 for the purpose of beginning the process of selling the property. The appellant then commenced proceeding in the Supreme Court on the 26th of November 2012, claiming breach of contract for failure of the respondent to honor a performance bond and subsequent agreements for funding necessary. The appellant alleged for the completion of the project and for failure to provide funding for operating and marketing costs of the Ocean Place condominium. On Ocean Place condominium, the appellant further claimed in paragraph 15 of its statement of claim that the debenture, inclusive of supplemental and collateral memorandum of deposit deeds, was invalid and unenforceable for non-compliance with Section 146 of the Companies Act, on the basis that the shareholders had not approved the debenture. However, as noted by the respondent, the action did not expressly challenge the exercise of the respondent's contractual or statutory rights to sell the property. So my understanding is, even though they filed that claim, it was insufficient to kind of stop the sale of the property because the respondent still had statutory rights to sell the property.
Right, and that statutory right is that power is given where? What section? What section?
156? 156?
Section 21 to 26?
I say I remember which one.
Not the paragraph now. You're talking about the actual legislation. The power of sale. Under section 21.
Okay. Section 21.
Go to section, let me see, look at your thing. paragraph 16. It says the provision under section 27 of the law of conveyancing and property act states in any action, whether for foreclosure or for redemption or for sale.
Ah, right.
Yes.
Okay, so it's under that
Mhm.
act that they still had rights to sell the properties. Still had right to sell, to start to begin to sell the property.
Yes.
Okay. The respondent filed a defense and counterclaim on the 26th of February 2013, defending the applicant's claim and itself counterclaim against Mr. Ballard, principal of the applicant, claiming inter alia
Mhm.
that Mr. Ballard, as guarantor, countersigned the agreement whereby the respondent was to extend the credit facility to the appellant up to the sum of 5,400, and also executed a guarantee and a postponement of claim dated the 28th of March 2006, guaranteeing the payment of the loan secured by the debenture and signed by the applicant on the 28th of April 2006. The respondent applied for, what the respondent applied for was successful on the application to strike out the section 156 claim in the statement of claim by ruling of the Supreme Court on the 14th of May 2013, which decision was upheld by the court on the 4th of September 2013. So that claim that that the appellant made was striked out. And so the respondent actually won that claim in the Supreme Court ruling.
Mhm.
Prior to September 4th, sorry, you saying something?
No, go ahead.
Prior to the 4th of September 2013, decision of the Court of Appeal, Mr. Ballard, by his defense to counterclaim filed on the 11th of July 2013, denied responsibility for repaying the debts of the applicant and the counterclaim that both he and the appellant were under extreme pressure and that he acted under economic duress and or under the undue influence of the respondent. Consequently, he claimed the debenture inclusive of the supplementary and collateral memorandums of deposit deeds was invalid and unenforceable. The respondent thereafter, on the 3rd of December 2013, filed a summons applying for an order for the sale of the property pursuant to subsection 27(2) of the Conveyancing and Law of Property Act order on the rules of the Supreme Court and under the inherent jurisdiction of the court. The appellant applied for an adjournment of the application, which was refused by the learned judge, who proceeded to make the order pursuant to section 27, subsection 2 on the 27th of February 2013. I would read the 2, 3, and 4, and 10. Is that okay, Ms. Archer?
Go
The
ahead.
paragraphs, that is the paragraphs that will be in question. So the decision was followed, that if the power of sale was indeed exercisable, the learned judge erred in law, and in fact, by failing to grant an adjournment so that the status quo could be preserved for the short time to allow the appellant to consider his position in light of the 9th hour information it had only just received. 3, that if the power of sale was indeed exercisable, the learned judge erred in law, and in fact, by failing to grant a short adjournment to allow counsel for the appellant to take proper instructions with regards to filing on the 9th hour affidavit by the respondent. 4, the learned judge erred in law, and in fact, when he exercised his discretion wrongly by refusing to grant an adjournment, when in fact, it was necessary and just to do so. And 10, that if the power of sale was indeed exercisable, the learned judge erred in law, and the fact concluding that the time allowed for limited disclosure of the seal affidavit were sufficient for the appellant to properly advance its meritorious review, I don't know if I call the word review, and or objections to the state. As previously noted, The respondent applied for the entire notice of appeal to be struck out on the basis that leave to appeal was not obtained from the trial judge. My understanding previously is that I didn't have a leave from the trial judge, so that was, they didn't obtain leave from the trial judge, and so that is why the respondent is asking for the notice of appeal to be strike out. The respondent subsequently also objected to paragraph, what I just read, 2, 3, and 4, 2, 3, 4, and 10 of the notice of appeal being entertained without leave pursuant to subsection 11 of the Court of Appeal. There is no doubt that paragraph 2, 3, 4, and 10 of the notice of appeal relates to interlocutory decision. However, the appellant also appeals by the same notice substantive findings of the learned judge, namely that there was no reasonable basis on which Mr. Ballard could advance the argument that the debentures was invalid on the grounds of misrepresentation, undue influence, and economic duress. And his decision to grant the order for the sale of the property covered by the debenture. Consequently, paragraph 2, 3, 4, and 10 are peripheral or not important to the main point of the appeal. So my understanding in that part of it is that Mr. Ballard is saying that he was misrepresented under undue influence and economic distress, but none of them had anything to do with the sale of the property. So it's almost invalid to what is like not important to what he was trying to say. On examination of the pleading in the action below, it is clear to us that the substantive claim in the statement of claim was invalid, was the invalidity, of the debenture on the basis of the non-approval of shareholders, and by the counterclaim subsequently filed remains the claim. Not even making sense. Okay, hold on. On the examination of the pleadings in the action below, it is clear to us that the substantive claim in the statement of claim was the invalidity of the debenture on the basis of the non-approval of the shareholders, and by the counterclaim subsequently filed remains a claim in action, but on the basis of misrepresentation, undue influence, and economic duress. The appellant's case obviously is that the validity of the debenture is central to the right of the respondent to sell the property pursuant thereunto. Now, I couldn't understand that part of it, Miss Archer. Really and truly, I didn't. But number 14, the breach, maybe you could explain that portion for me, please, number 13.
You back to paragraph 13?
Yeah, I didn't quite understand
Examination
paragraph
of the
13.
pleadings and actions below.
Huh?
The one that starts on examination of the pleadings and the
Yes.
actions below.
Yes, on examination.
Okay. So on examining of the pleadings of the action below, it's clear to us that the substantive claim in the statement of claim was the invalidity of the debenture on the basis of the non-approval of shareholders. You know what that means?
Yeah, the shareholders didn't approve of the debenture.
Yes, the
Mhm.
loan.
Right, the loan. Mhm.
And by the counterclaim subsequently filed remains a claim in the action, but on the basis of misrepresentation. So undue influence and economic duress. So he's using all of these terms to say that the arrangement itself is invalid, and it could be based on any one of these. So when you read your notes in unit 6, it speaks about entering into a contract on the grounds of misrepresentation or undue influence or under economic duress.
Okay.
So then it says the appellant's case obviously is that the validity of the debenture is central to the right of the respondent to sell the properties pursuant thereto. So his whole argument in all of this in this appeal was what? What was he arguing?
Mr. Bal, he was saying that they didn't have the right to actually sell the property because they weren't aware of what was happening, or they breached the contract and not giving them, what are they, like giving them more money or stuff like that. And he was almost forced into doing whatever decision that they made, because he signed everything back in 2006, but he's saying that he signed under, they misrepresented what they said, and he was under economic duress. So he was like pushed or forced into doing whatever it is that they did. I don't know.
Yeah, that's what he was saying. But
Oh.
but I'm trying to find, after this appeal, he appealed again.
Yes, he did.
Yeah, he appealed again, and that matter took place in November 2014. He went through this whole process again. So in 2014, when he went before the appeals court again, they summarized and said in early 2006, he entered into the loan with FCIB for the development of the condo on PI. And between 2006 and 2009, and pursuant to the debenture in 2006, FCIB on separate occasions dispersed to him large sums of money. And he failed to properly service the debt. As such, the demand was given for the full payment of the sums loaned. So he refused to pay. And FCIB began proceedings to get an order for sale. And they did that pursuant to Section 27 of the Conveyancing of the Law of Property Act. And the court on November the 14th said the appeal was dismissed and one half of the cost went to the respondent. So according to contact, his contact on your matter.
It's 7 o'clock.
Yeah, justice contact on both. He said the trust of the appellant several grounds of appeal seek to impugn the trial judge's refusal to grant an adjournment to the appellant or its counsel to seek further instructions. It was never contended by the appellant that the learned judge lacked the jurisdiction under the Conveyancing and Law of Property Act to order the sale of the property. In any event, this court is convinced that on the evidence before him, the learned trial judge must have been attuned to the principles governing the making of an order for sale under Section 27, subsection 2 of the Conveyancing Law of Property Act. So what does Section 27, subsection 2 state?
Hold on.
Because that's the one that you're doing now. That's the appeal. Didn't he refer to Section 27, subsection 2? Let me go down in your document. Anyone else read this one?
17.
Go paragraph 16.
Yeah, we read that already though.
Right. So that's the section that he used.
Yeah, we read that already. Remember you read that? I thought you were talking about something else.
Okay, so the judge said under Section 27, subsection 2 of the Conveyancing Law of Property Act can only be invoked in an action for foreclosure or for redemption or for sale or for the raising and payment in any manner of mortgage money.
Okay.
The claim by the mortgagee judgment in the amount of the mortgage money from the mortgagor cannot, in context, be construed to be an action for raising and payment of the mortgage money.
Okay.
Everybody got that? A claim by the mortgagee for judgment in the amount of the mortgage money from the mortgagor cannot, in context, be construed to be an action for raising and payment of the mortgage money. So on the basis of the bank's defense and counterclaim filed in February 2013, the court had no jurisdiction to make an order under section 27, subsection 2. Because none of the claims and any of the actions or counterclaims fell under any of the categories in section 27, subsection 1, required to invoke the jurisdiction under section 27, subsection 2. However, by an amendment made on the 13th of December 2006, the respondent properly invoked the jurisdiction of the court. That's FCIB.
Okay.
So once the jurisdiction is properly invoked,
Mhm.
the court has a wide discretion in ordering a sale under the section, not only by the mortgagee, as expressed in section 27, subsection 2, but also by the mortgagor.
Yeah.
The act is a remedial one. One effect of it being to allow a mortgagor whose property is worth more than the mortgage money, but who cannot raise it, to obtain a sale and get the benefit of the surplus. The act being remedial is to be construed liberally. The court has power to impose terms so as to take care that no injustice shall be done to anyone. And the legislature has given its jurisdiction to make the order at any time before foreclosure absolute. So the judgment, he said, it is my considered view that the appeal against the learned judgment filed on behalf of the appellant, Peace Holdings, impugning that judgment, should be dismissed.
Yes.
On the 13th of December, 2013, FCIB applied by someone to the court under section 27, subsection 2 of the act, and also under 31 of the rules. And he said the learned judge allowed the bank's application under section 27. On this footing, the judge did not find it necessary in the circumstances to rule definitively on the application under order 31.
Mhm.
So the force of the order was to confer an unimpeachable title on any purchase of the property from the bank. The bank had earlier, pursuant to the debenture, appointed receivers in respect of the property who were
Yes.
actively canvassing the sale of the property.
Mhm.
And then the judge went on to refer to section 1 of the Law of Conveyancing Act. A mortgagee, where the mortgage is made by deed, shall, by virtue of this act, have the following powers, to the like extent as if they had been in terms conferred by the mortgage deed, but not further, namely a power where the mortgage money has become due to sell or to concur with any other person in selling the mortgage property or any part thereof, either together or in lots, by public auction or private contract, without being answerable for any loss occasioned thereby. So the power of sale granted to the mortgagee is applicable only if, and so far as, a contrary intention is not expressed in the mortgage deed. And that's why customers, when they sign for a mortgage, they must read the deed. And shall have effect subject to the terms of the mortgage deed and to the provisions contained in it.
Thank you.
Okay, so you have to be, when you read this again, I want to see if I can get, I have it hard copy, this
Okay.
later appeal, but I can't find it no longer on the internet, so I'm gonna look for it. If I can't find
Yeah, I
it,
can find it. I
I'm
can
gonna
find
scan it. Yeah, I'm gonna scan it and send it to you.
Okay,
So-
thank you.
Yeah, there's a writing on the top. I don't think I have no writing nowhere else. So you can read it.
I
And
can
you would see where the judge goes into in section 27, subsection 2,
do. Mhm.
and he explains the power of sale.
Okay. Thank you.
Okay, so I put this on the side so I can send that tomorrow.
Appreciate it.
Okay.
Hi, good evening.
Good evening.
Question, Ms. Archer. In reference, earlier you mentioned you were speaking about the power of sale and the mortgagee's right to sell, etc. And then you mentioned, I think you mentioned section 16. I was trying to determine where's that information coming from? Was that on the actual case or?
Yeah. Paragraph
Is that the
16 on the actual case.
Okay,
Yeah, it refers to section 27, subsection 2.
okay, thank you.
Yeah. But I mean, this appeal didn't stop. There's another one that
Yeah.
happens tomorrow.
Keep appealing.
All right, thank you.
Who's next? Don't be shy.
Good night, I don't mind going.
Okay, go ahead then.
Okay, thank you. Good night. The case you gave me was on Evelyn Frith and Scotiabank, Bahamas Limited. This was a Court of Appeal case, and it was recently heard actually and ruled on over in well, back in 18th of May 2022. The case here was it was a rather simple one if you want to look at it in certain respects. And the case here was really considering whether or not this appeal should be allowed to go up to the Privy Council. I didn't have the previous details on the other case, which is actually based on which they were. I'm trying to take basically going against from the Supreme Court, but in this case here that was given, it outlined some of the reasons why or what must be considered by the Court of Appeal before a case can be presented before the Privy Council. And in this instance, it really considers two specific areas. First, is there a right of appeal? And second, if there's not a right of appeal, should the court exercise their discretion to grant the applicant leave to go to the Privy Council? And in this case, it was actually denied the appeal in and of itself. The appeal was overall shut down and denied, mainly because number one, there was no right of interlocutory appeal. There was also no statutory exception. There was, by the few of the appellate judges, no serious issue to be considered. And at the same time, there was no uncertainty of law that came up and came about as of this case. The reason those things were outlined was because the application was truthfully based on, well, submitted on those grounds. They tried to say that there was a right of appeal, mainly because a right of appeal is written out in, where is it? They have it stated there, section 23, I believe, of the Court of Appeal Act. And it's really, the first thing it really speaks about is that the sum must exceed $4,000, and then the judges of the Court of Appeal should have erred or misdirected themselves in a law and in fact when it comes to the original decision. And in this case, it was found that none of those things happened, so therefore there was no right of appeal. And in relation to the other matters, there was nothing really that was in question in law and or in fact. Just to be more clear on the first point, which is the right of appeal, it does come from section 23(1) of the Bahamas Court Appeal Act. And it says that the property matter must, like I said earlier, exceed $4,000. You have to have leave of the court to then apply for your further appeal up to the Privy Council. But it has to be subject to certain restrictions, limitations, and conditions that could be prescribed by the judges in those cases. And then this is paragraph 7 of this. It says there's no doubt in this case that the subject of dispute was over $4,000. Counsel for the applicant contends that as the value of the claim exceeds $4,000, the appeal falls into the category of an appeal as of right. However, the decision of the court in Freeport Container Port against Jermaine Campbell SC, where Justice Evans, Appellate Justice Evans delivered a judgment, he really and truly laid out that appeal to the Privy Council to recognize it falling into the two categories. Like I said earlier, this case really was hammering out this point here. That appeals as of right and appeals which require the leave of court appeals of right are considered to be those with the property over the $4,000 amount and upwards. All other proceedings, save for claims emanating from the court's constitutional jurisdiction, require the leave of the court. And this point was actually dealt with by the court in Standard Chartered Bank Switzerland SA against UBS Farmers Limited. And it simply was considered that there really is truly no right for appeal in this case. The second sections that they really started to look forward was as to there being any kind of grounds for discretionary leave for appeal from the court. And it was truthfully found, well, it was found by the judges that there was none. It was argued and claimed that the Supreme Court judge actually made an error and omission in their orders as it relates to some of the funds in questions from the mortgage and basically how it was applied. And that is really that was really the area where a lot of this case was continuously appealed and brought forward. And because the council argued that it was erroneously ruled on, they tried to invoke the fact that the slip rule should apply, and the slip rule basically allows the courts, the slip rule allows the courts to, where do I have it? Yeah, it's a process by which the court may correct any accidental slip or omission in their judgment and or order. And the appellant judges actually found that in this instance, the Supreme Court judges had not made any slips, incorrect or omissions in their judgments in their order. So therefore, the slip rule was not needed to be questioned and or reviewed at this point in time. Also, the judges found that there was no uncertainty, like I say, as it relates to the law in this matter, as it referred to numerous either statutory provisions and or common law rulings on the matter that actually followed along the line of what is considered still the law. And as such, in the conclusion of it, the judges, the appellant judges said that they have the view that the law regarding the application of the slip rule does not require clarification. There's no uncertainty in the law, no claim by the appellant to an exception under this rule. And for these reasons, they dismissed the application for leave to appeal to the Privy Council, as they found this of being without merit. And they said the cost of the respondents to be taxed if not agreed. Not particularly sure what that part is for.
All right, so you can see how these cases are beginning to lean towards, and most of the cases towards the bank when they exercise their power of sale. So let me read the one for you for Lawrence McKinney and Bahamas Development Bank. No one has that, right? I don't think so. Did I assign that to anybody?
It's assigned.
I was
to
supposed to be for
Beth.
Miss Johnson, but she's unable to make it tonight.
Yeah, because I have her name here and I see she wasn't up. Okay, so this case to me was an interesting one because it addresses the exercise of the mortgagee's power of sale. And it touches on what constitutes a valid demand. So in the ruling that was delivered in May 2014, Justice Claire Herboyne found that the bank demands of the customer were not valid demands under the law, as they didn't specify the amount owing and it didn't extend to the plaintiff the required 30 days notice under the mortgage. So it is an interesting ruling and it follows the principles set out in the celebrated case of Cookmere Brick Company Limited and Mutual Finance Limited. You all remember seeing that name in your notes? You had to say yes. So it says that this action has a very long history And in the re-amended statement of claim, the plaintiff alleges that the defendants did not pay the monthly rental payments to his mortgage account as was agreed between them. So this action has two commercial arrangements. The first is the sale by the first defendant, that's the bank, to the second defendant, the Butterfield, and then the third defendant, Roll. The two lots were situated in the Oaks Airport subdivision, and they had been mortgaged to the bank in 1991, and then they got a further charge. So the sale by the bank was pursuant to the power of sale that was contained in clause 610 of the mortgage. So the plaintiff would repay the loan together with interest secured by way of mortgage and a combined monthly payment of $2,050. The further charge and interest was to be paid by a combined monthly payment of $590.51. So the total amount he had to pay was $2,640. Now, the second transaction was a rental agreement between the plaintiff and the defendants, and the plaintiff agreed to rent the mortgage property and the defendants at a monthly rate of $2,500. So that means that he would have had to find the difference. Initially, the defendants were to pay the monthly rent directly to the plaintiff, but the plaintiff relocated the Acklands, and the defendants agreed that they would deposit the monthly rent directly to the plaintiff's mortgage at the bank, which they did until July 1995. That is to say, after they entered into an agreement with the bank to purchase the mortgage property for the sum of $220,000. You understood that part right there? You see what just happened?
Yes.
What happened? What happened? What happened? Yes, bankers, what happened?
It seems as though the bank had an agreement with one client. After the client, I guess this is what I'm saying, after the client, and they were also in negotiations with another client who was actually, paying most of the mortgage, etc. It seems as though they ended up offering the property to the second client, who was actually the client paying the first client rent after a certain period of time. I don't know, maybe.
Yes. You see how mixed up this is?
So it meant that they defaulted in payment at some point?
So in the re-amended statement of claim, the plaintiff alleges that the defendants, the two tenants, did not pay the monthly rental payments to his mortgage account as was agreed between them. He also alleged that the property was conveyed to the defendants at an undervalue of $222,000, when on his valuation, the property was valued at not less than $750,000. He also claimed that the price at which the property was sold was far below market value and disputes the amount that the bank claims is owed on the mortgage by the plaintiff. So the bank avers that its power of sale was validly exercised in all the prevailing circumstances. The bank denies that it wrongfully sold the premises and that it sold the said premises for a price less than its market value. The bank also contended that it duly accounted to the plaintiff as to the proceeds of the sale and the resulting amounts due and owing on the mortgage by way of letters that they sent to him. In his reply to amended defense of the bank, the plaintiff reiterated that he did not receive notification of a default in his mortgage as contended by the bank. In the amended defense of the defendants, it was denied that the plaintiff at any time inquired of them as to whether the rent was paid to the office of the bank. So one side is saying they didn't receive notification. On the opposite side, they're saying that he never bothered to confirm to the bank that the payments were being made. They said they also aware that they could not have informed the plaintiff of arrears as they had no knowledge of the status or terms of the mortgage. So the mortgage itself said it was a term of the mortgage that, quote, the borrower shall pay to the lender the principal sum of $128,000 with interest at 11.5%, by 120 consecutive monthly installments, each of $2,050, representing repayment of principal, interest, and insurance thereon, and the rate aforesaid with monthly rates of such installments be paid on the 6th day of March next, and each subsequent installment to be paid on the 6th day of each succeeding month until it's paid in full. So clause 610 of the mortgage provides section 22 of the statute or the equivalent provision of any subsequent amending or consolidating act shall not apply to this security, but the statutory power of the said shall be as between the lender and the purchaser, from the lender being exercisable at any time after the execution of the security, provided that the lender should not exercise the said power of sale until the payment of the monies hereby secured have been demanded and the borrower has defaulted for 1 month in paying the same. Then clause 7 of the mortgage said, the full payment of the principal and outstanding and all arrears of interest hereunder shall forthwith become due and payable, and all a mortgagee's powers of sale, foreclosure, action, possession, and appointment of a receiver, and remedies of a mortgage shall henceforth be or become available to the lender in enforcing its security hereunder in the event any of the following contingencies. Any installment of principal and interest or any part thereof shall remain unpaid for 30 days after the same shall have become due, whether formally demanded or not. So the plaintiff claims that he had made arrangements for the second defendant and the third defendant, who were his tenants, to pay the rent to the bank, which could count as the mortgage payment. The bank claims that the plaintiff defaulted on regular payments and the bank exercised its power of sale and sold it to the second and third defendants for $220. So this was the plaintiff's claim. The plaintiff withdrew the allegations of fraud and collusion, and also the claim to set aside the sale. Mr. Winder stated that the plaintiff's claim concerned the exercise of the bank's power of sale against the mortgage property, whereby the bank sold the mortgage property to the second defendant and the third defendant, who at the time of the sale and purchase were tenants of the plaintiff, making monthly payments to the bank on behalf of the plaintiff. The bank exercised its power of sale and sold the mortgage property to the defendants without having first made a formal demand for the outstanding mortgage payment or giving the plaintiff notice of the sale. Mr. Winder summarized the remaining complaints of the plaintiff as follows. By virtue of clause 610 of the mortgage, a formal demand for outstanding mortgage payments was a precondition to the exercise of the power of sale. Winder stated that even if the 12th of May letter had been served on the plaintiff would have been given only 19 days within which to redeem the mortgage. Furthermore, he stated the evidence will show that the bank exercised its power of sale before the expiration of the 19 days, and that on the 29th of May, that the bank accepted the offer of the second and third defendants to purchase the mortgage property. The bank also failed to take steps to secure the best price, and the sale was at an undervalue. Mr. Winder stated that the bank did not advertise the sale of the mortgage property or take any other step to obtain the best price, that the bank did obtain an appraisal or seek professional assistance from a real estate agent to determine the value of the property. The bank agreed with the plaintiff not to exercise its power of sale in consideration of the mortgage payments to be made directly to the bank by the second and third defendants. So the plaintiff then, he called two witnesses. He called himself and he called Mr. Ernest Morse, who was his friend. So this is what the plaintiff said, Mr. McKinney. He gave a little background of how he rented the property to the second and the third defendants at a monthly rate. He stated that the bank had agreed to receive the rent from his tenants and apply those sums to his mortgage. He also said the bank also agreed to inform him if there would be any defaults in the payments. He confirmed this evidence in cross-examination. In his viva voce evidence, was that he and Andrew Sanford discussed the arrangement by telephone, and Sanford told him that he would be at the mortgage property each month to collect the rent from the defendants. He also stated that on the 5th of October, 1995, he received a letter dated the 12th of July from the bank advising that due to arrears in the loan account and that the bank had accepted an offer to purchase the mortgage premises. He stated that he never received any letters from the bank advising that his account was in arrears or that the bank intended to exercise its power of sale over the mortgage premises. He insisted that he had informed the bank of his move to Acklands in 1991 or 1992, and that he did not recall receiving any letters from the bank in Acklands or at any of his other business places in New Providence. He maintained that Sanford agreed to let him know of any delinquency. He admitted that he was in default in 1993 and that the amount of the default stated in the bank's letter of the 12th of May, 1993 could be correct, but he insisted he never received that letter, nor the letter of the 26th of July, 1993 to Post Office Box N3606. He stated that the mortgage premises was sold without the bank giving him the opportunity to either bring his account current or to secure a higher offer to purchase. He thought the mortgage property was valued at about $750, but he did not have the building appraised by a professional real estate appraiser. Then Mr. Morse, he gave his witness, and he said that he had accompanied the plaintiff to a meeting with Butterfield on the 5th of May, 95, at which Butterfield agreed to make rental payments of $2,500 monthly directly to the bank. He stated also that at the same meeting, the plaintiff telephoned Sanford and informed him of the arrangement which he and Butterfield had made, that Butterfield would pay directly to the bank the rental payment of the $2,500. Morse also stated that Sanford also confirmed that should any delinquency or default in payment occur, he would advise the plaintiff. Morse did not say how it was that he could hear Sanford's side of the telephone conversation. So in his viva voce evidence, Morse admitted in cross-examination that he only witnessed the handwritten agreement, that he did not know the nature of the document, that the conversation between the plaintiff and Mr. Butterfield did not take up much time, and he did not recall the conversation between the plaintiff and Butterfield, that while he was at the meeting, he heard the plaintiff's side of a telephone call, and that the speaker system was not activated, and he did not know who was on the other side of the telephone conversation. So now you see he was a terrible witness. Mr. Morse stated that the arrangement between the plaintiff and Mr. Butterfield was reduced to writing and that he signed a written agreement. At the trial, he identified his signature on the agreement. Now the bank. John Archer stated that the bank's loan detail report dated the 13th of April, 1995 revealed that the plaintiff was in arrears of his loan in the amount of about, say, $8,000, and interest in arrears of $9,000, totaling $17,000. Archer also said that as a result of the plaintiff's default on the loan, the bank exercised its power of sale pursuant to the mortgage, and that the sale was concluded on the 20th of February, 1996. He stated that by way of letter dated the 6th of April, 1998, the plaintiff was duly advised by the bank that the loan balance stood at $58,437.12, and that the bank was advertising the other properties situated at Oaks Field. The letter of the 6th of April concerned the plaintiff's home in Oaks Field and notified the plaintiff that the account was seriously in arrears. Archer also stated that a final notice dated the 10th of January, 1997 was sent to the plaintiff. The letter informed the plaintiff that he was in arrears in the tune of $56,000 and that he had until the 24th of January to bring his account current. In cross-examination, Archer testified that he was responsible for advertising the mortgage property for sale and accepting bids. He informed that the sale of the property was advertised, but he could not produce a copy of the advertisement. The best he could do was to produce an invoice from the Nassau Guardian, which did not specify, did not specifically identify the advertisement. That is unfortunate, as not only must the bank prove that the property was advertised for sale, but also the contents of the advertisement, as that could influence the sum prospective purchasers would bid on the property. An advertisement which simply identifies a property for sale would not attract as high an offer as would advertisement which describes the structure on the property, if any. So Archer confirmed that many letters were written to the plaintiff concerning the status of his loan, which was in default. However, he couldn't say if any of them was actually delivered to the plaintiff. He testified he did not know that the plaintiff had moved to Acklands, but he agreed that the bank had in his files an Acklands address for the plaintiff. So Archer claimed that the bank was properly and diligently discharged its duties in relation to the plaintiff in accordance with the mortgage and received numerous bids and accepted one of those bids. Archer stated that the sale of the mortgage property was not done secretly. He stated that no time during his dealings with the plaintiff's matter did he, the bank, or any officer under his supervision agree to accept or to collect any rental income for and on behalf of the plaintiff from any tenant to offset the agreed monthly payments. And he stated that it is not the policy of the bank to make such arrangements, as it alters the primary duty of the borrower to make the agreed monthly payments under the loan facility. So now comes the real estate broker. He said that he was a licensed real estate broker, and he verified that the property was valued at the price it was sold at in 1995. He appraised the mortgage property, not the time of the sale, but years later on March 2010, using the retrospective approach. I don't know what that means. So Mr. Andrew Stanford, evidence in chief, was that based on bank reports, he could confirm that the plaintiff was aware of the status of his accounts and knew of the steps the bank was taking and had taken and the advances that were due and owing to the bank's order. He said his conversations with the plaintiff would appear that the plaintiff always acknowledged that he was in default of his mortgage. And he stated that at no time did he agree to collect any rents on behalf of the plaintiff, and further stated that to do such was not the policy of the bank. Then Mr. Butterfield spoke, the second defendant. He stated that there was a strong inference that the plaintiff knew that his mortgage was in arrears, and the plaintiff approached him just 2 weeks prior to the bank approaching him, Butterfield, to inquire whether he wished to purchase the mortgage property for what he felt was an inflated price of $750,000, and that he declined the offer. He enrolled and put a counteroffer to the bank in the amount of $180,000, which the bank rejected. Their second bid of $220,000 was accepted. He testified that the bank gave him no information as to the value of the mortgage property. Butterfield stated it was highly unlikely that the bank would have accepted a bid from himself and Roll if they were delinquent in paying the rent, which they paid directly to the plaintiff's mortgage account at the bank. Butterfield stated that at no time did he or Kim Roll, his business partner, reach the agreement between themselves and the plaintiff. Butterfield testified that once the offer accepted by the bank, he stopped paying rent to the plaintiff. And however, Roll made 2 further payments of rent on the 20th of June, 95 and 17th of June, 95. He testified that he had no communication with the plaintiff concerning the purchase of the property. As to the contents of the building, this evidence was at the time of the sale, the equipment was generally in a state of disrepair or infested with vermin and not fit for any purpose, and so he and Roll just got rid of them. Kim Roll stated that she had no knowledge of the arrears nor of the status of the terms of the plaintiff's mortgage. She personally made the payment to the plaintiff and sometimes made payments directly to the bank after being directed to do so. She said she believed that the regularity of their rent payments to the plaintiff's mortgage account, that the bank approached her and Butterfield about purchasing the property. The evidence was that an officer of the bank approached her and Butterfield to invite them to make a bid on the mortgage property. She stated that she and Butterfield made an initial offer for $180,000, which was rejected, and then they made a bid of $220,000. What you see going on here now? Anyone see what's happening?
Was the bank operating within the law? Was it within their rights to approach someone like that? telling them to submit a bid.
Hmm. And you haven't heard anything from your client? Because they're standing on the ground that they didn't realize that he was an Acklands.
And
It
but you said
almost,
you,
Go ahead.
sorry, go ahead. Fabian.
no, I just wanted to say it almost comes across as if the bank was almost trying to collude with these people
That's
to
what-
try to.
That's the
Yes.
impression I got. Right, like they, because
Kind of, you know, they do their little slick stuff.
Mm-hmm.
Yeah, I like if they just wanted I suppose it off their books at whatever cheapest rate, they could have gotten it off their books and call it a sale. Not keeping their real client in place.
Ms. Archer, what I'm trying to figure out here is the client himself, knowing that you have a mortgage payment for X amount of dollars and you move to Acklands. Shouldn't there be a level of responsibility where you at least, I don't know, check in with the bank, go online, or do something to make some effort? Because I mean, I'm not gonna move away and just leave a mortgage up to my tenant saying they're gonna pay. I'm gonna check that every now and again. So I'm just wondering, what is it? Because it seems like the client is a bit laid back, or maybe he's trusting whatever the tenants said that they would do. Yeah, but I still would check that every now and again. I can check that. So yeah, I was just wondering because the client just seems to be a bit laid back as well, you know?
Mm-hmm.
Ms.
but
Archer, let me,
didn't sorry, James, 1 second. Didn't they say that they were making the rental payments though? The
Yes, they
payments
were.
were being made?
And they say that's the reason why the bank approached them, because they saw that
Right. So the
but
payments were?
payments were.
I mean, he's moved to Auckland, so okay, the client's making payment. You ain't gonna check in at least twice, 3 times a year to see what's going on with your mortgage. I don't care if they're making it in 1990. I check in it 1990, 1991, 1992. So I'm not gonna do a one-time check. I'm gonna check in on them every now and again to make sure things are being serviced. And if I see something that's wrong, because that's a lot of money, $58,000 or $56,000 to accumulate, that's a lot of money to say, you know, you being a borrower not checking in at your mortgage at all. So that ain't no 1-2 months, that's several months. So you can't just go Auckland and not pay attention. I'm just saying it from the opposite end, but I do see the bank, you know, getting involved in some things maybe they shouldn't be involved in. But the client should have checked in on that mortgage at some point. Because it's more likely it's a 20-year, let's say it's a 20-year mortgage. If it's a 20-year mortgage and you have tenants in your place, you only need to check for the first 2 years? No way. You need to pop in every year, at least twice a year to see what's going on. For that to accumulate to 58,000, because at first it was only 7,000.
Yeah.
So I mean, I just,
sorry, not to cut you off, but I just wanted to ask the question. When it was at 7,000, did he not go in and then said that they would have a rental and that this person would be paying, and then somebody was to inform him of how it was being paid or not paid?
Yeah, that's what he said. But the
Yeah,
bank
that's
is-
what I thought. And so the bank did not follow
bank
through.
said they
with
don't-
their
they don't do
agreement.
so that person was the bank who was supposed to inform him, or his friend, the bank?
One was his friend.
That was
Was
his friend or the bank who was supposed to inform him?
The first one was his friend, Mr. Ernest.
Yeah, the
Moss.
friend.
Moss
The
couldn't,
friend was renting, but wasn't it, did they not go into the bank and he said to them that this man would then start paying the $2,500 for rental directly to them?
yes.
That's what I thought.
Mhm.
So.
That's what I'm
the
saying.
bank
So it
did
seems
not
as though,
follow- Mhm.
oh, go ahead.
I was saying that then that the bank did not follow through on their promise to try to get a hold of him. So now here it is, they now just discovering he was in Athens.
I don't
I
know.
thought Ms. Archer
I don't
said
know,
that
I
they
don't know.
admitted that they have, I thought Ms. Archer read something where they admitted that they, their files do show an Ackland's address, like they knew how to find him.
When Archer gave his evidence, Archer said, Archer testified that he did not know that the plaintiff had moved Ackland's, but he agreed that the bank had in his files an Ackland's address for the plaintiff.
Okay.
Exactly.
So how you could say you didn't know that he moved to Acklands, but there's an Acklands address
Mhm.
on his file?
And fine. That was my thing.
And they
Yeah,
didn't
the
give
bank
him
doing
the
some
full
stuff.
time, right? They didn't give him the full time that they were supposed to serve him notice either.
Yeah.
So look, they had ulterior motives, I feel, and were
Yeah.
rushing through to that sale.
Yeah, but I do agree. I like I said, the bank was doing some things that maybe they shouldn't have been doing. But I was basically speaking to the gentleman who was in Acklands, because I know sometimes persons go away and they do ignore their mortgages. Like you're in
Yeah.
Acklands,
He
not
had a
because you're in
right to.
Acklands means that, you know what I mean? Your life stop or your
Especially
mortgage
with that
payment
type
stop.
of money,
Yeah,
that type of
Yeah,
investment, he should have followed up. Yeah, definitely.
yeah, he should have followed up.
we can just believe that this man, because he said he was going to pay, mean that he was paying.
Okay,
You
hold
know,
on.
he,
We have to finish
like-
it first. Let's see what they come up with. So what it says here. Says the plaintiff cases that at the date of the sale of the mortgage property to the defendants, the bank's power of sale had not yet arisen, as the bank failed to serve a demand notice on him in accordance with clause 6(10) of the mortgage. The bank's case is that the plaintiff always knew that he was in default of his mortgage payment, as he knew that the monthly rent was insufficient to cover the full mortgage payment. Further, the bank submits that when read together, the net effect of the demand letters dated 12th of May 93, 26th of July 93, 20th of April 95, 12th of May 95, 2nd of July 96, 10th of January 97, 6th of April 98, is that the plaintiff was in default of the terms of the mortgage and that he was duly notified of his default. He was not. The bank had a duty not to serve a demand notice on the plaintiff in accordance with clause 6 subsection 8 of the mortgage, which provided that a demand for payment on any other demand under the security may be made by notice in writing by the managing director or any officer of the lender, and any such notice given to or served upon the borrower shall be deemed to be sufficiently given to and served upon the borrower in bold, if addressed to the borrower and left or sent by registered post to registered office or any address as shall from time to time be notified by the borrower to the lender. And any such notice posted as aforesaid shall be deemed to be given on the 5th day following the posting thereof. So that meant that the bank had to serve the plaintiff personally or at the last known address of the plaintiff. The plaintiff, go ahead.
Not to cut you off. So if you send it to the post office on the registered mail, if he picks it up or not picks it up, 5 days after the posting, is deemed to be served?
Yes, let's read on. I'm gonna tell you what the judge say. That's why I picked this one. So the plaintiff's evidence was that he moved to Acklands in 91 or 92. And although Archer, remember Archer represented the bank, testified that he did not know that the plaintiff had moved to Acklands, but he agreed that the bank had in his files an address, an Acklands address for the plaintiff. How could the bank have come to an Acklands address for the plaintiff in its file? That's the question. On the balance of probabilities, the bank would not have had the plaintiff's address unless the plaintiff had given his address to them. So having observed the plaintiff, Archer and Sanford in the witness box, and considering the answers they gave to questions put to them on balance, I'm satisfied that the plaintiff notified the bank of his relocation to Acklands and his contact address there, because there's no other way they could have gotten it in the file. He had to have given it to them. So the bank was not particularly careful in addressing its various demand letters to the plaintiff. Some of the letters were to the plaintiff at Nassau, NP Bahamas, others to him at Malcolm Road, PO Box N3603. But that was not the most important aspect of the demand letters on which the bank relies at paragraph 7 of the amended defense. What is most important is that each letter demanded payment of a different sum of money, and none of them gave the plaintiff the required 30 days notice. The letter of the 12th of May, 1993 demanded payment by the 26th of May, 1993. The letter of the 26th of July, 1993 merely informed the plaintiff that the property would be advertised for sale due to the delinquent position of the account. The letter of the 20th of April, 1995 demanded payment by the 4th of May, 1995. The letter of the 12th of May, 1995 demanded payment by the 31st of May, 1995. And then the property was sold before the expiration of the notice period. In the result, the number one demand letter satisfied the requirements of clause 6, subsection 10. Mr. Rigby, the attorney, attempted to string together all of the demand letters and to make one proper demand letter out of the lot. The judge says that is not permissible. In the result, I find that the bank did not make a proper demand for payment of the outstanding balance. Hence, the power of sale had not arisen at the time of the sale of the property. Further, the bank did not satisfactorily prove service of the demand letters, such as they were. The letters were to be personally served, in which case the person who personally served the demand letters on the plaintiff ought to have given evidence of service. There's no evidence to that effect. If the letters were sent by registered post, the bank ought to have produced the receipt issued by the post office. Mr. Rigby, the attorney, submits that the plaintiff was aware that he was in default of his repayment obligations under the mortgage, and that seems to be the evidence. He seems to suggest that the fact that the plaintiff knew that he was in default lessened the duty of the bank to serve proper notice on the plaintiff. Of course, Mr. Rigby's case is that the combined effect of the letters referred to in paragraph 7 of the amended defense is that due notice was served on the plaintiff. The judge says, I fear there is a misunderstanding of the true purpose of serving notice on a mortgagor. The issue is not whether or not he knew he was in default of the mortgage, but whether or not he was given sufficient time in which to redeem the mortgage. You heard that?
Yes, I have a question.
Go ahead.
In terms of, because, okay, let's say it's bank practice. You're given your 30-day notice. That's the first instance, you're given 60-day notice. Your second demand letter gives you 30-day notice. Your third demand letter can give you 15-day notice or 2-day notice or whatever, just to demand again. So his first letter then, once he issued the second letter, it cancels the first?
Yeah, I don't think they run like that. Yeah. But see,
Because the first,
the mortgage.
yeah,
That's
but
inside the Bancroft itself.
I wanted to know if his first demand letter to the time, the last letter, I mean, from the first demand letter up to this point now, that is not 30 days, that would not constitute 30 days.
You see the judge, so you can't add them all together.
Yeah, I know you can't add it all. Okay, you can't add it all together, but the very first one, up to the point of this state, that did not constitute 30, even
No,
if we look at the first.
No, the letter of the 12th of May, 93, demanded payment by the 26th of May.
Or the end date.
30 days.
No, the end date. The end date. Okay, I got it.
Right. So in his mortgage deed, it had a clause, and that clause said, that was the judge put in bold. If addressed to the borrower and left or sent by registered post to registered office or any address, I shall from time to time be notified by the borrower to the lender.
And that's in his deed.
That's in his deed.
Okay, so, okay.
Yeah, and any such notice posted as aforesaid shall be deemed to be given on the 5th day following the posting thereof.
All the more we need to read those mortgage documents because the lawyers just come up with the terminologies and stuff, and we don't read straight through.
Sometimes they
No,
use-
Miss Thames, the bank, BOB has a standard mortgage document. You
but has
can't
to be the same
add or
altogether.
take away from it. You can't alter it at all.
But
Okay,
is it
so
the
that's
same
not-
document from people who've had mortgages for a long period of time?
I think
No, I
this
think
one,
Rissa was updated.
it
and
was
they-
updated.
Yeah,
in
it was
recent
updated. They
years.
sent it out to the lawyers.
Mhm.
That's
And-
probably one of the reasons they maybe updated it, because you could have made so many changes to it. Yeah,
Right.
Yeah.
interesting.
As the acts change, you have to amend your document.
But you know,
I'm-
something, Mr. Archer, something that stands out, okay, like how the mortgage payment was like 2,600 or something like that. I was wondering like how the gentleman, he had them paying less than the mortgage amount, so he knew that he had to put the difference,
That's what I
right?
was,
I know the case doesn't address it, but.
no, it doesn't, no.
And the delinquency would add up.
Yeah,
Okay. Yeah, because he would have some idea you're not putting it there, so, yeah, okay, I guess the case doesn't reference the point like that. Okay, that's fine.
no, because he brought his case not on the figure itself, you know, he didn't say the figure wasn't right to him, but he knew,
Okay,
he knew he wasn't making the full payment. But
right.
he was saying that they never sent him a demand letter. And
That's
Oh,
so
his-
okay.
that's the case. And
Oh,
because
I
they,
okay.
just understand.
Well,
That's
they-
how the court is look at it. Hey, I ain't come here to discuss that
Yeah.
piece. I we here discussing this piece.
right. He discussing that the proper demand was not made.
So you'll have to get something like an amendment or something like that to address something else if the bank wanted to, or if the person wanted to, right?
That piece up.
Yeah, I just saying, just asking.
Yeah,
That's another court case and another set
Yeah.
of payments. Everybody's
Yeah.
just rip off of the ball. That's a rip off of the ball.
Interesting though, very interesting.
Okay, so hold on, we ain't finished yet, almost finished. So the issue is not whether or not he knew he was in default, because remember, one of the side, one of you all was saying that he knew he was in default. But so the judge is saying that's not the issue. But it's whether or not he was given sufficient time to redeem the mortgage. So the cornerstone of a mortgage is the mortgage's rights to redeem. And I've been telling you all that from 2 to 3 classes ago, right? You cannot impede a mortgage's right to redeem.
Yeah,
And-
I remember that.
Right, and you can impede that by not giving him notice, the proper notice. So
Yes,
in the
fair
instant, you have to give him that opportunity. So in the
Yes.
instant case, the plaintiff and the bank agreed that the plaintiff would have 30 days after demand for payment has been made in which to redeem the mortgage. Section 22 of the Conveyancing and Law Property Act provides that the mortgagee's power of sale shall not be exercisable until demand has been made and the mortgagor has made default in repaying the mortgage for certain defined periods of time. However, by Section 21 of the CPLA, the parties may vary the statutory period in any manner. And in this case, by clause 610, the parties agreed that Section 22 of the CPLA shall be varied, and that the statutory power of the said shall be as between the lender and the purchaser, from the lender being exercisable at any time after the execution of the security, provided that the lender shall not exercise the said power of sale until the payment of the monies hereby secured have been demanded and the borrower has defaulted for 1 month in paying the same. So none of the demand letters on which the bank relies gave the plaintiff 1 month to pay off the outstanding balance. And that is where the bank went wrong. That is why at the time at which the bank purported to exercise its power of sale, the power of sale had not arisen. Another question for
You
determination.
can repeat that piece right there, please, Ms. Archer. You were talking about the bank and when the power of sale became valid.
Okay, none of the demand letters on which the
Yes.
bank relies give the plaintiff 1 month to pay off the outstanding balance. Remember you'd asked me earlier and I was telling you the dates? The first letter was the 12th of May, 93. And the demanded payment by the 26th of May. And the next one was the 26th of July. And then the other letter after that was the 20th of April, 95. And demanded payment by the 4th of May. And Attorney Rigby, who was representing Roosevelt Butler, was saying when you put all the letters together, he would have had adequate notice, and the judge said no. So now the judge is saying none of the demand letters on which the bank relies give the plaintiff 1 month to pay off the outstanding balance. And that is where the bank went wrong. That is why at the time at which the bank purported to exercise its power of sale, the power of sale had not arisen. So the next question is whether the bank took reasonable precautions to obtain the true market value of the mortgage property at the date at which it decided to sell the mortgage property. And it gave you the case of Crookmere Brett versus Mutual Finance. Mr. Rigby, the attorney, carefully reviewed the authorities on the question and emphasized that the bank is not a trustee for the mortgagor as regards the exercise of the power of sale. That should sound familiar to you. And the judge says, I agree. The learned editors of Halsbury Laws of England, volume 77, says a mortgagee owes a duty in equity to exercise the power in good faith for the purpose of obtaining repayment and to take reasonable precaution to secure a proper price. Lord Justice Salmon in Crookmere held that the mortgagee is under a duty, quote, to take reasonable care to obtain what I call the true market value at the date of the sale, end quote. The bank's evidence was that the property was advertised in the Guardian, but it couldn't produce any copy of the notice. It is important for the court to have sight of the actual advertisement to determine whether it sufficiently described the mortgage property so that bidders would have a clear understanding of the extent of the development on the property. How is the court to determine whether or not the bank breaches duty to obtain true market value at the date of the sale in the absence of evidence as to the contents of the advertisement in the Nassau Guardian? The offers to purchase exhibited at tab 15 of Archer's witness statement are in all respects to a single family dwelling house and not the commercial property, which is the subject matter of this action. And so they are of little probative value in arriving at a determination whether the bank took a reasonable care to obtain the true market value at the date of the sale. The only other evidence of the steps taken by the bank to obtain the true market value of the mortgage property is that the bank approached the defendants and requested them to put in a bid for the property. Butterfield and Roll gave evidence that the bank initially approached them to purchase the property for $750,000, which is the valuation the plaintiff placed on the property. They declined to do so. Why did the bank first approach the defendants with an offer of $750,000? The outstanding balance was far less than that amount. The defendant's counteroffer was in the amount of $180,000 and then $220,000, which was accepted by the bank. That approach by the bank does fall outside the category of reasonable steps to obtain the true market value of the property. The bank's evidence as to the exercise of this duty to obtain true market value at the date of the sale does not come up to proof. A finding that the power of sale was not properly exercised, however, does not impeach the title of the purchasers. Under Section 23, subsection 2 of the Conveyancing and Law of Property Act provides that where a conveyance is made in a professional exercise of power of sale conferred by this act, the title of the purchaser shall not be impeachable on the ground that no case had arisen to authorize the sale, or that due notice was not given, or that the power was otherwise improperly or irregularly exercised. But any person damnified by an unauthorized or improper or irregular exercise of the power shall have its remedy in damages against the person exercising the power. I also know that there is a conflict between clause 610 and clause 718 of the mortgage. The former, providing that the bank's power of sale shall not be exercisable until payment of the mortgage monies has been demanded and the plaintiff has defaulted for 1 month in paying the same. The mortgage is the bank's document, and to the extent that clauses 610 and 718 are in conflict, they have to be construed in favor of the plaintiff. Always remember that. If there is a conflict, the court puts the blame on the person that prepared the document, which is the bank. Until the plaintiff had made default for 1 month in paying the same. So when it came to the true market value, he said the 1991 appraisal by Mr. Ferguson put the value at $350. The 2010 retrospective appraisal by Christopher Armley valued the property at $260,000. However, the latter appraisal was retrospective, while the 1991 appraisal was current at that date. The bank did not commission an appraisal of the property. You had a variation in the value of the property. In 91, it's appraised at $350. In 2010, they did a retrospective valuation at $260. The defendants offered $220. The bank took $180. So counsel for the bank argued the court to adopt the Armley report. Counsel for the plaintiff urged that the court to adopt the Ferguson report. Alternatively, to use the median of the two appraisals. Alternatively, to adopt the plaintiff's appraisal. The plaintiff did not show how he arrived at the valuation of $750, and that figure is rejected. Mr. Ferguson was deceased at the date of the trial, and the Armley report is retrospective, which Mr. Armley said was an accepted method of valuation. I am satisfied that the fairest approach would be to take the median of the Ferguson report and the Armley report for a figure of $305,400. The land was sold for $220,000. I accept that the appropriate measure of the loss occasioned to the plaintiff as a result of the improper exercise of the power of sale is the difference between the value of the property and the actual sale price, or $85,400, and the bank must pay that sum to the plaintiff. If I'm wrong in adopting the median between the Ferguson report and the Armley report, then I direct an inquiry and accounting into the value of the property at the date of the sale as commended in the court in Crookmere Brick and Another Mutual Life. So Butterfield and Roll accept they rented the mortgage property from the plaintiff for $2,500 and they stopped paying in July 1995. That the sale was completed in May 1996. You heard what happened? The tenant stopped paying rent.
They help with the default.
They stopped paying rent in July 95 and the sale was completed in May 96. So it's practically a year. 10 months later, they occupied the property for 10 months without paying rent to the plaintiff. The sum of $25,000 is therefore due and owing by the defendants to the plaintiff, and judgment is entered against Butterfield and Roll in that amount. The plaintiff alleges that during the time the plaintiffs occupied the property, his chattel property, which were included in the rental agreement between Butterfield and Roll within the premises, were destroyed. Until the execution of the conveyance from the bank to them, the plaintiff was still the owner of the chattels in February 1996. The chattels belonged to him. Butterfield said they got rid of the chattels because they were vermin infested and of no worth. It would follow then that damages ought to be given for the destruction of his personal property, to which he still owned, regardless of the state or condition of it. The plaintiff evidence as to the items that were in the mortgage property during Butterfield and Roll's occupation as tenants were as follows: table and chairs, boots, freezers, refrigerators, walk-in fridges, screens, carpets, air conditioning, deep-fat fryers, stove, desk, couches, fire extinguishers, electric salad bars. Butterfield and Roll did not dispute his evidence. the plaintiff did not produce evidence of the value of the chattels other than his estimate. There's also no evidence to support the claim that repairs were made to the mortgage premises by the plaintiff. Justice Clay Habboring concluded, the bank improperly exercised its power of sale when it sold the mortgage property to the defendants for the sum of $220,000. As a result of the improper exercise of the power of sale, the plaintiff suffered a loss of $85,400, and I hereby order that the bank pay to the plaintiff the sum of $85,400. I cannot say whether the plaintiff is indebted to the bank for any further sums, and if he is, how that might impact the amount the plaintiff actually receives from the bank. If I'm wrong in adopting the median between the Ferguson report and the Amley report, then I direct an inquiry and accounting into the value of the property at the date of the sale, as found in the case of Crockmare. The court also finds that the plaintiff is entitled to rent money in the amount of $25,000 for the period of June 95 to February 96, and I hereby order that Butterfield and Rule pay the sum of $25,000. I also find that the second defendant and the third defendant are liable to the plaintiff for the destruction of equipment which belonged to him, which were in the premises. In that case, I order that damages be assessed. And then they or she ordered that the court pay the plaintiff costs with respect to the plaintiff claim against the bank. And Butterfield and Rule were also to pay the plaintiff's costs. Now you see how important it is to read the provisions within the trust deed.
Right. There's actually a question there. I see you mentioned where the bank was to pay the plaintiff $85,000 plus. And then I know the judge in his ruling, he said something about he cannot say if the plaintiff owed the bank anything, etc. So I guess if he had like a little balance or something with them, they would deduct that from the 85 and pay him the difference.
Yes.
Okay. All right.
Yeah.
Okay, thank you.
But then don't forget, now he's getting $25,000 from the defendants who didn't pay the rent, who didn't pay the rent after they were in negotiation with the bank to buy the property.
Right. So, because I was thinking, maybe take the 25. Okay, since the 25 was supposed to be paying our mortgage in any event, I'm just saying, maybe they'll probably take the 25 from the 85 and pay him the difference in addition to whatever damages for legal representation, etc.
Yeah, but see, the two defendants have to pay that $25,000 to him.
Okay, all right.
Their contract was with him.
Okay.
Right, and then the bank has to look to see if there is any difference that he owes them. They will take it from the 85 because you can't mix the two sums up.
Okay, all right, fair enough. Thank you.
Ms. Archer, the document that the case that you've been reading, was that sent to us? Because what I have was the ruling on the valuation of the chattel.
Hold on. You should have. I was hold on, let me see. Where is that?
Send that one.
No,
At least
we
I can
didn't.
see that one.
I only have the ruling.
You didn't get that one.
Okay.
Where
pulled it
the
up
judge
online.
didn't accept
This one is written up too. But I can scan this one tomorrow too.
Okay.
Yeah, I can scan this one. That's a very good one. Because it lays out how important it is to read the provisions in the mortgage deed, and then you see how the court interprets it. You remember what I saying? You could write whatever you want, but when it comes to litigation, the court has to interpret it. Depends on what the provisions are in the act. All right, we have time for the Mitchells.
Okay, good night.
We can do the Supreme Court, please.
Okay, you want to do the Supreme Court first?
Yeah, do the Supreme Court first.
Okay, I have the appeal.
Okay, Shantina, she's in on A.
No, she's not.
Okay, but I could wrap it up in a nutshell.
Okay, all right. So
Coming out of the appeal.
You can do the appeal.
Okay, so just quickly, this is a case with let me just get the names of the people. I know they're the Mitchells. Philip Mitchell and Brenda Mae Mitchell, second defendant. Philip Mitchell, first defendant. And the plaintiff is Finco. So in a nutshell, Finco would have approached the Supreme Court to get vacant possession of the Mitchell's property. Mitchell and that vacant possession was granted by the courts. However, Mitchell made an appeal of the order. And so it first started with Finco on the 14th of September 2009, commenced proceeding against Philip and Brenda Mitchell, seeking judgment for the sum due under the mortgage between the parties. And the order for vacant possession of the Mitchell's Twynham Heights property was granted in favor of Finco, noting that Finco, the plaintiff, was entitled to exercise his power of sale over the subject property. The order was granted the 15th of April, 2014. Mr. Mitchell filed a notice of appeal motion on May 20th, 2014. He was granted a 90-day stay of execution of the order. And so the Court of Appeal dismissed Mr. Mitchell's appeal on the 21st of March, 2018. They would have stated that Finco did have the right to vacant possession. So Mr. Mitchell, in his feelings, felt that the Court of Appeal needed to be appealed. And so he put in an appeal to the Privy Council. So he then filed a motion of appeal motion seeking leave to appeal to the Judicial Committee of the Privy Council on the 9th of April, 2018. By this notice of appeal motion to the Privy Council, Mr. Mitchell seek an order for stay of the proceedings pending the outcome of the appeal. And this application, the word was, this application remained extant, which means it's still existing. Yes?
Mm-hmm.
And so on April 14, 2020, a writ of possession was issued to Finco. Mr. Mitchell filed the present application seeking a stay of proceedings pending the appeal to the Privy Council, and also seeking to set aside the order for vacant possession together with other writs of possession. He felt that it ought to also be stayed or set aside. The defendant, Mr. Mitchell's application to set aside the order for vacant possession, the writ and the writ of possession was dismissed. And so he was ordered to pay the fines and the costs of the application to be taxed. And so the court became functus officio. Yes, I had to look that up, which means I got this definition from Black Law Dictionary. The meaning for functus officio is given as follows: having fulfilled the function, discharged the office, or accomplished the purpose, and therefore of no further force of authority. And so that was pertaining to the Supreme Court plus the Court of Appeal, because here now Mr. Mitchell is taking this to the Privy Council, and so he is thinking that he can have this stay pending the outcome from the Privy Council. And so the 6-year period for the enforcement of the order for vacant possession must be, 1 minute, Ms. T, my husband's snoring.
We can't hear him.
Okay, good. Okay, and so from the date of the Court of Appeal, the judgment happened.
She went mute. Okay, she coming back now. Thought you're gonna completely mute.
We can hear now?
We can hear you now.
Okay, good.
Okay.
So the 6 years period for the enforcement of the order for vacant possession must be counted from the date of the Court of Appeal fulfilled, sorry. I'm just making the points in the ruling,
Mm-hmm.
okay?
But you know what was so funny about this case when he said that the mortgage was invalid?
Sorry, before the ruling, for vacant must be counted from the date of the Court of Appeal judgment, which happened in 2018, rather than the Supreme Court judgment of 2014. All right, so we further note that there were to be an appeal to the Privy Council, then it would be from the date of the delivery of the Privy Council's judgment. So further, the Homeowners Protection Act came into force in 2017, and it is therefore not applicable to the present action, which was commenced in 2009. Okay, and so also the order of the ruling of the Supreme Court has no applicability to the present case, because the issue as to whether that is an order 77 action was settled by two courts. This court therefore has no jurisdiction to consider this ground. The defendants have appealed, which is the only court, and so the defendants sought to throw off the courts because he started to sought to utilize the machinery of this court by virtue of a series of hopeless applications toward the right of the bank to obtain vacant possession of the subject property.
Hey, what up, y'all? That's your internet?
Can be used to circumvent. I'm on my my phone. My internet is not working. It's cutting in and out. Hey.
It like stretching the words.
Oh.
We can hear you now, though. Go ahead.
Okay. So here it is. He was trying to use all he could to just not get this vacant possession happen to him. And so the court was like kind of a little upset that he's using all of these appeals and he really has no ground for the appeal because the Supreme Court ruling was upheld. Okay. So he came up with another story that he had new information, new facts, well within that they were not knowledgeable that he needed to present. And this was the most jokiest. His facts, his new facts was that if they, if the court allowed Finco to repossess his home, and if this court does not grant him the stay, he and his family will be rendered homeless. Yes. They will lose their sacred and holy sanctuary where they gather to rest, pray, and give thanks to the heavenly creator. And they will face the predicament of catching COVID-19 with the possibility of dying from it. He therefore employs the court to grant him a stay pending his appeal to the Judicial Committee of the Privy Council. Indeed, his plea is emotive. That's what the court cited him as being. And so the bank opposed the application and relies on the following documents. The original summons filed on the 14th of September 2009. The judgment of Justice Milton Evans, whom we refer to as Evans J, dated the 15th of April 2014. That's the possession judgment. The notice of appeal motion filed on the 28th of May 2014. The order of Evans J granted on the 28th of May 2014, the stay of execution order. The ruling of the Court of Appeal pronounced on the 21st of March, 2018. The notice of appeal motion filed on April 9th, 2018, seeking leave to appeal to the Privy Council. The writ of possession filed on the 23rd of January, 2020. The order of Justice J pronounced on the 15th of April, 2014 and filed on the 14th of April, 2020. That's the order for the vacant possession. And the writ of possession filed on the 14th of April, 2020. The summons, the affidavit of Mr. Mitchell filed on the 5th of February, 2021. And the affidavits of Trevor J. Lightbourne filed on the 11th of February, 2021. So with all of these facts, we are still, and I don't know if that came about since this case, Ms. Archer.
Privy Council?
The Privy Council.
Privy Council ruled on the 10th of November, 2021. Permission to appeal should be refused because the application does not raise an arguable point of law. Furthermore, the appeal is devoid of merit and has no possible success and is an abuse of process.
And he just exercising all the mechanics of the court, and they feel that he was abusing those mechanics.
Yes, he represented himself.
His wife didn't even show up.
Yes, he represented himself. Through all of this, he represented himself. Remember, he said that the mortgage itself wasn't valid.
Wow.
He had an outstanding balance of $319,164.86. And he says the mortgage is invalid.
Oh my gosh. I didn't get the amounts in my appeal section, so that would have come from the Supreme Court ruling.
Yeah, he said that he argued that the terms of the mortgage cannot bind them, as what they signed was not a mortgage deed. And he said that, listen now, remember when contract law, one of the elements of contract law is you must have an offer, an acceptance, consideration, and an intention to create legal relations to form a binding contract. So he also argued that there was no intention to be bound by the terms of the documents, as the terms were not available at the signing. He said the mortgage is invalid as a fraud with the result that he is unable to claim for indebtedness on any of the three loans. He has to be crazy.
You remind me of the Dean case.
Yes. Yeah.
Okay, so in conclusion, in the premises, I will dismiss the defendant's application in its entirety. Mr. Mitchell shall pay the bank's cost of and occasioned by the application. Such costs are to be taxed if not agreed.
So he spent more money, he should just keep his mouth shut.
I think he's retarded from the time he said he could catch COVID-19 and die if they put him on the house.
Like that's supposed to stop anybody.
Okay. So that was it in a nutshell.
Yes. So that was another good one. But when he represented himself and
You know, he said it wasn't good. All the way to the Privy Council.
Not good, not good at all. I said, oh my Lord, something is wrong with this man. Something is wrong.
But his wife know why she didn't show up.
Because she's
8:26.
She would have been embarrassed. Neil is Neely on? There she is. It's 8:26 and then we'll stop, or you want me to stop now when we do Bentech and what's the next one? Bank of the Bahamas and Mr. Maycock. And then we have Teresita Johnson, Finco.
Bank of the Bahamas, and Maycock.
Yeah.
You send that one? I don't see that one.
You don't have that one? Okay.
I don't have that one now.
Okay, I'll send that one. Let me look at my email, what I sent. Peck, McKinney, okay, you have Bentec though.
Yes.
Okay, who's supposed to be doing Bentec? Okay, I can send Bentec. And I could do, I'll send Finco and Teresito. You don't have that one either, right?
Finco and Teresita.
Teresita Johnson.
No.
No? Okay. I'll send that one, don't worry. Worry not.
I have Finco and Teresito.
Oh, okay.
You have that one?
Yeah.
I don't.
So do I.
Finco and Teresita.
And BOB versus Herman?
Yeah.
Yes.
Who was that one of the attached to the email that was sent by Pratt, or y'all got another email?
No.
The
That was
last
attached to the
email I
email
got.
sent by Miguel.
Okay, so in that one, I only had two for the Mitchells, which was the appeal, Bahamas Development Bank, Bentec. I don't have, I had about 5. I don't have anything for Bank of the Bahamas and that under Teresita.
How you get missing that?
I don't know. Let me see. Let me open up the email again.
Krista, did you read BLB and Herman Maycock?
Unfortunately not, Miss Archer.
So should I leave that one for next week, Mr. Maycock? I have a lot of Fincos, eh? I need to find some more BOBs.
Just none will we losing the case.
Oh, Lord. No, y'all won in this one. This is on whether or not the right to enforce the judgment with statute bar.
Well, that sounds interesting.
Yeah, it is a good, interesting case. Okay, Finco versus Teresita. Did I sign that name?
That was assigned
Me,
to Miss
Marissa.
Marissa.
Okay, so the email that I got from Miguel on February 13th, it had 1, 2, 3, 4, 5, 6, 7 attached, and none of them, I'm looking at it right now, none of them was the Bank of the Bahamas one. So is there another date, guys, that I'm missing?
I wonder if I'm missing it too.
Miss
because I don't
Archer,
see-
you emailed us on February 14th
Let me go to my sent box.
with the
It's February 14th, Miss Archer Center.
Okay, I
Yeah,
didn't
with
get
the
an email
links?
from Miss Archer.
Okay, that may be the reason.
Okay, forward it. Because don't forget, I used the email from Miguel. That's why I always like Miguel to send it to make sure.
Now, depending on which email you use, remember his initial email, I was left off and I had to be added later.
But if I use the one for today, would that work?
Yes, the one where he sent the link for today.
Yeah.
Yes,
I'll
I'm
use
included. I saw that one.
the cases.
So yeah, I don't have anything from you on the 14th.
Okay. So someone want to forward that to her so she can have those cases?
Miss
Who wants to-
Stacy,
who
what's your email address? Or you could send it in. Go ahead.
Stacy, Stacey,
Right.
Knowles,
Okay.
17 @gmail.com. Thank you so much.
Yes, no problem.
Who wants to do Teresita? That one isn't long. Power of sale. Again, it's Crookmare and Mutual Finance the cases. Volunteers? Oh Lord, this goes so quiet.
Which one you say, Miss Archer?
Finco and Teresita Johnson.
That is assigned to me, but I'm not prepared. I haven't read it because it's supposed to be for next week.
Oh, Lonnie just asked. I said we could do it tonight or we could leave it for next week.
I would
So
prefer to
we'll
do
leave
it
for
next week.
Yeah, we could. We could leave that one and we could leave Maycock. Who has Maycock? My paper. Maycock supposed to be Stacy.
Maycock was sent on which email? Which date? Sorry.
That one, I am not too sure.
No,
Did I?
Maycock is Stacy.
The same one I just sent you, Stacy.
Yeah,
Okay,
it's
so
also
I just got it.
14th.
Mhm.
Okay,
That
so-
wasn't
so that was-
Stacy.
No?
Sorry.
It's Katora. I'm
No,
asking
it
the
is
date.
Herman Maycock. It is Stacy. BOB versus Herman Maycock.
It's Stacy.
So, oh,
The date. I'm asking about
February,
the date. that it was-
February 14th after 10 o'clock. That came straight from Miss Archer.
Krista, sorry, can you flip me to us
I
because
think-
I'm looking in my emails and I don't see it either.
I think that was sent to my work email and not my personal email, because I don't have that. The last thing that I have would have been from the 13th.
That's Krista?
Victoria,
No.
was sent to your Bank Bahamas email.
Yeah, it
And
wasn't sent
then-
to my personal email. That's what I'm saying.
Right.
So I don't have
Mhm.
access to it right now.
And James, it was sent to your Bank of the Bahamas too. It might have bounced back depending on the size.
The size. Okay, can someone send that to my personal, please?
If you put your email addresses in the chat, I can go ahead and do that for you guys. Wow,
Okay.
finish up.
Okay, appreciate that. 1 second. Good night, how are you?
I'm looking at mine. Okay, so in the email for the 14th, you got Maycock,
Yeah,
Johnson.
baby.
Those two, right?
You're
Right, I
welcome.
see where it says
So-
Unit 6, BOB versus Herman Maycock, and that's assigned to me. So that's for next class?
Yes. And
Okay.
then Finco versus Teresita, and I have that assigned to Marissa. And then I had Cassandra assigned to Crockmare Brick versus Mutual. I send the link.
Ms.
Yeah,
Archer, I'm just seeing why some of those questions on that test, I had no clue what was going on. Anyhow, I didn't get this email on the 14th, and I think some of this had to do with the exam on the 20th. No? With this Quinnell, Malfi, and Sylvan.
everybody knew Quinnell. We discussed that in class.
I noticed you didn't say anything about the test results. Are we to take it that they were that disappointing?
No, I got them late.
Oh, okay.
Yes, I'm not finished. Oh, no, I would have opened with that. You know that. Next class, I will tell you all exactly what happened. But they told me you all were very happy in the exam.
They told you what?
You all were very happy.
Oh, okay.
No?
I see what you meant when you talked about those multiple choice. They're very, very tricky.
Either you know it or you don't. That's what she said.
Exactly. I was like, wow, okay.
Yeah.
But that means, yeah.
Whew.
I asked,
I found where some of the answers I feel could have gone either way, like could have been a A or D or all of the above. They were kind of, it was tricky.
See, I tell them but short answers. I told them.
I'm glad you said it, Miss Forbes.
Thank you.
I did try to persuade them, hey, Krista. I did say, stick to short answers. I tried. But I like.
Trust me, I think for the final exam, everybody's gonna be on board for the short answers.
No, mixture.
Oh, they want mixture.
Mixture?
Take a vote.
Mixture. Because the short answers focuses on the cases, so at least we could, have a balance.
No, I can put multiple choices
Maybe.
cases,
Maybe.
And in this one, I did it.
Yes.
James, you put your email address in the chat so Krista could forward the email to you.
I on my phone. I'm gonna go ahead to expand and I hang up. Thank you for letting me back in, Ms. Archer. But Stace, thanks. What I did was I went to my work email and I was able to forward it myself. Thank you so much. Mhm.
Okay.
Thanks, Krista.
All right, so I sent you all the link for Crook Mayor also, right?
Yes, it was in that same email, the same one we're passing around now.
AIB Finance, I sent the link for that. And I sent the link for Colonial Mutual Insurance. Now, did I send you all Quality Business Center and Anthony Munnings?
Yes, ma'am.
And SPL versus Mukesh Lapinda?
Yes.
And Mukesh Lapinda versus SPL?
Yes.
Yeah, because Fountain is doing the Supreme Court and then you're doing the Court of Appeal.
Okay. Yes.
Yeah, okay, so all those cases being sent.
Repeat that one for me, please.
You're doing Mukesh Lapinda versus Scotiabank in the Supreme.
Okay, thank you.
And
Thank you.
Krista will do, yeah, Krista will do the Court of Appeal. Those two cases are looking just at in general and the bank's duties and the customer's duty. And it's a very good case if you've never read it. It has to do with funds being missing from the customer's account and the customer notifying the bank after a certain length of time. And the customer is of the view that have a passbook, and we don't use passbook anymore. Everything is ATM. You should check your balances. So it's a good case. So you'll see in the first instance, she won. And in the Court of Appeal, she lost. So it's a very good case. All right, so since everybody has their cases, I think we could end for the night. Now, make sure now when you're reading these cases, notice how the judge brings in, first he tells you what the issue is, then he refers to the actual mortgage deed, looking at the provisions in the mortgage deed, and then he goes and he applies either an interpretation of those provisions or he brings in case law. And the more of these you read, the more you will see how the judges uses the leading cases. And that's the key to interpreting mortgages. Because yes, they may all have the same clauses or different provisions. But when it comes to exercising the power of sale, like in Pentec, you see when there's a difference in figure, what the court says, what should be done. So I may add some more cases for those who don't have any to do now. Latoro, Shantina, Kristen, Fountain. So
you could reassign one to Miss Johnson because you did hers tonight.
Who, Katara?
No, Yvette.
Oh yeah, I am on Yvette.
Miss Archer, could you repeat those steps again for the court?
Okay, I said that the court, the first thing it does is looks at what is the issue? What are you here for? After that, the judge then looks at what evidence you brought to support your issue. From that, the judge then goes and looks at what does the law state, the act that covers the provision you're talking about. and then it uses the case law to interpret that provision. And once it's done that, then it applies it to your issue.
Okay.
So that's how law works. What is the facts? Because remember, and you notice as we read, we'll say the plaintiff said this, the defendant says this, and then the judge says, I value more the evidence that is given by the defendants, or I value more the evidence that was given by the plaintiff. And then he starts his discussion as to what is the issue, what is the law. And when he said, what is the law? If he either refers to a particular section in the mortgage deed, then he goes to what the actual legislation says, and then he uses the same case law you see in your note to back up his analysis when he decides whether or not the bank can exercise its power of sale.
Okay.
So each one of the cases as you read it is on a different point in this whole process of exercising the power of sale.
Okay, when my phone timed out, did you talk about the finals in terms of you'll give us the cases again that we'll be looking at?
Yeah, I already told you that.
Okay, no, my phone timed out.
Yeah.
All right, thank you.
When I write the final exam, I will tell you the cases to focus on.
Okay, great, thanks.
Yeah, I don't leave you. That's why I say the scenario questions to me are much better for students because they read the cases. We would have already discussed them in class. And so they know when the question, if I say a particular case, they know what that case is about.
Right.
And so they focus on putting in their mind what are the main points the judge was making in the case. So if we go to the one with Lawrence McKinney and Bahamas Development Bank, you know that was about the provisions in the mortgage deed, and the bank didn't follow its own provision that it had drafted. And they didn't give him notice, adequate notice, according to the provision in the act. So if I tell you that there's going to be a question from Lawrence McKinney and Bahamas Development Bank, you know exactly what that case was about.
Right. Yes, thank you.
Right. So I normally find students do much better on scenarios because like I said, they can study the cases, they analyze it, and when they look at the question, know exactly what it's about.
Okay.
I try to take them from different angles. Because I can always find other cases on the same issue.
Right. Thank you.
Okay. But we far away from the finals now.
Ms.
All right.
Archer, Shantina said that she's going to reach out to you directly to explain some stuff that's going on.
Okay, okay, not a problem.
So, Ms. Archer, like the test we recently took.
Yes, the midterm.
I didn't hear you?
The midterm.
Yeah, the midterm that we took, like the cases, were they considered like scenario questions? No, that was a different format.
No, the three last questions, remember you all said, I must give you some scenario questions, so even either what they would look like on the final.
Right.
Those last three scenario questions are based on cases.
Okay.
And I gave you all the names of the cases.
Right.
Yeah,
because you gave us like specific cases you wanted us to address, right?
Yes.
Okay. I just didn't, I mean, I think like one of them, I really didn't remember a short listing that as one of the cases to study.
Yeah, so I gave you the cases that were relevant to the scenarios. And in some cases, I gave you two cases that could apply to a particular question. I'll see when I read it. Don't stress
Because I
it.
was thinking like when you gave us, like if you gave us, you said you would say this case or this case. So you wanted us to describe any one of those cases?
Yes.
Oh, okay.
Don't stress yet.
Think what you
Let me mark it first
You
and then.
serious, madam, Ms. Archer.
Yeah, she wanted you to apply the case that you knew to the scenario that she gave.
Yeah, but it had to be one of the cases that she had there. And I said, I didn't remember. Like, I remember us discussing them in class, but I don't remember them. Like when she gave us a short list of cases to focus on, I don't remember. Yeah, I didn't remember, you know, like some of them being on that short list. That's what I was saying.
Oh,
Yeah, that's what I mean.
Okay.
yeah, they would have discussed the same principle as the one that we did in class.
Yeah, okay.
Yeah, so I'm supposed to send you all Lawrence McKinney and Peace Holdings, right?
Yes.
Lawrence McKinney, yes.
Peace Holdings, just those two.
Something, you have something extra for Peace Holding? Because I remember seeing some Peace Holding. There's another part to it?
Yes, there should be another part to it.
Oh, okay, all right.
Let me see what I have
That's
here.
the part you say you're gonna get, Miss Archer.
Okay, because I have Peace Holdings, November 2014. Which one you have?
14th of April. Sorry, the 20, oh, sorry. This is the Court of Appeal.
Yeah, all is Court of Appeal. But
Wow.
how many pages is the one you have? Let me go to the.
I think it's 12.
12.
12 pages, yeah.
Oh.
I think what you was reading is something different, Miss Archer, that you said that you
I
had
have
to.
one that's 19 pages and my other one is, yeah, 19 pages.
Yeah.
No, I don't have
We
that.
don't have that one.
Okay, so I'm gonna scan this one too. Yeah, 19 pages. Okay, so I have that and that. And anything else I have to send? Everybody
You have
has
some homework that you're supposed to get back to us on the Shantytown situation. We weren't able to find online.
No, I did not forget. The Supreme Court site is not up. I see they're talking in the newspapers about it. And I have someone right up to this morning trying to pull that down so I can get it for us to read.
Awesome.
Yeah. Because it did take her 5 years to come up with a decision. And I think if we can get it, we can read it and go through it.
Okay.
So that would be good. Yes, I did not forget. No, did not. Because that's still a process. Everybody is still agitated about that and wants something done. So we'll see. But I am trying to get a copy of the ruling so I could share it with you all. Okay?
Yes, ma'am.
Right. So I'll see if I can find some more cases if you all don't mind.
Okay.
What you said, Fountain?
No, I didn't say anything. I know I was recently looking into that same case as well. And you're right. What her name is? Justice Thompson. She did take about 5 years. She actually heard the initial application. I think it was an application for a judicial review, really brought forward about the Shantytown model and made and stated an injunction to prevent them from actually starting it. Like it's somewhere on the Supreme Court side. They started to look it up as well. But overall, she decided to remove the injunction and allow the government to proceed in this action. But right now, it seems like Lincoln being taking up that course of action better than anybody else, and he on his own path.
Yeah, didn't they arrest him?
Yes,
Several times.
He was recently stopped over the weekend for trying to destroy and demolish a shanty town in his own capacity.
Yeah.
Yeah, going, we gotta watch out for him.
You know what?
I don't know if his head going. I think he's the only one that actually trying to take action. The way he might be doing it might be, kind of outlawed. Sometimes desperate times call for desperate measures, and I think people are just fed up. But I think the ruling that we were trying to find, Fountain, I don't know if you saw anything when we looked that day in class when we were looking on the site, the initial ruling, we were trying to determine what was her rationale or her reasoning in putting the injunction in place in the first instance, and there was nothing on Google or any site. Everything just talked about it would just recently happen. I think that's what Ms. Archer was looking for, the initial ruling to find out how she came up with that, what she based it on.
Oh, it's the same thing I found. Actually, yeah, it's the same thing I found, and there was nothing indicating really and truly the reason for it. But I guess just in discretion, she decided to grant the injunction because it was the Shantytown residents who applied for the injunction, and she just granted it to them just to really prevent them, at least give more time for basically a decision to be made on it, because it's a deeply disturbing matter for the public at large. So the courts really need to make sure they come down on the right side, which is the whole benefit of, I guess, granting the injunction to allow the judicial review process to take a longer time on it.
5 years?
5 years, that's how long she took.
I was about to say, when people losing their homes in the court, they get 60 days to vacate.
Yeah.
But illegal residents have up to 5 years to enjoy somebody else's land. That's weird.
Yeah, that's a very long time.
I think it was it being a sore matter, and I think she ruled on the side of emotions, really. To see that the homes were being just destroyed. And she wanted us, meaning the courts and the Bahamian government, to really, give it some time. Let's really think about this. So I think that was why her ruling.
5 years?
I think money talk.
If Lincoln didn't come up some more,
it would have been 10 years.
It would have been 10 years, yeah.
I think money talks. I think that's the bottom line, because some of the people who have them, the illegal immigrants working or on these land, I heard that they're collecting rent from them. So it's a lot more going on than the general public is made privy to. So I don't think she's too sentimental, because they could care less what really happened to people when they let Arawak's home push down the church and all these other things. They don't be sentimental then.
No.
Yeah, I agree that in this instance is a deeper issue. It ain't just housing, it ain't just the shanty towns. Is those two, is legal immigration. You actually have Bahamian citizens who live inside these places. So many things is actually going on. But I don't know if that warrants the 5-year time period, but that's how long she took.
5 years is a very long time. And the thing is, it really raises the question that if the previous government was still in power, would we have received it?
Ms. Archer, you took the thoughts right out of my head, because I was saying that 5 years sound like a whole election cycle.
Yes.
So you think if the previous government was in power, we would not have received the order to now
We might
go ahead?
We may still be waiting.
It might still be waiting. Remember now, when they had the elections, he got a lot of votes from them. Those who could have voted.
Yeah, that's why I said there'd be a lot more going on. Why I think no progress is made. The few people who, like Brandon McCartney, or different people who you see start to make some headway, then you see the rug just ripped from underneath them. You know, there's a lot of things be going on that we don't know about.
You don't
Yeah.
know about it. Yeah.
As small as
Corrupt.
the country is, yes.
Corruption.
In the papers last week, they were saying that on the corruption index, we haven't moved. And that's something that we need to address. Internationally, we're still at the same spot, same ranking. That's an issue.
Because we have the
Definitely.
same players, same
I'm just
recycled
gonna say
players.
because just all recycling and somebody pointed out to me no longer than 2 weeks ago, you know, we come up with all these different parties, but truth be told, it's only 2 parties.
It's only 2 parties and they
That's
recycle.
it.
the same people.
And that's all.
It's the same
All
people.
doing the same thing because all are friends.
I
That's
was
what
about
it
to
is.
say that exactly. All of them are very close. They don't mind all the posturing and the carrying on in the house. That is before our
That's
entertainment.
just for
That's what
show.
that's
That's just for show. Yeah.
entertainment. Yeah, but
Then
they
you
all
see a
friends.
picture with them sitting up eating stew fish together, and they standing godparent for this one child, and they grinning up and
And
skinning up at church
exercising
and all this
together.
stuff. Okay, that's
I'm
right.
listening to something, but I heard this what I've seen.
Thank you. God, that's for Boo Boo the Fool. We all upset and they ain't talking to this one and they ain't speaking to that one because of
Okay.
whatever, but they the bestest of friends.
Yes, ma'am.
And to add to it, you know, things really have not changed because for one, I wanted to do something and I'd be like, wow, you mean I have to get back into politics in order to get this thing done? It's just not right. I just thought I could just do it being a citizen of the Bahamas. I didn't know I had to join the team. You know what I mean?
sure
In order for me to
And you
get
better
my
join the right team at the right time.
That's it. That was so sad. That was an eye opener for me. You know, I really thought we had evolved. But yeah, Miss Archer, I guess we can be there on them rankings. Mhm.
Yep, we will
Sad.
be. It is sad. It's sad. There's a lot of issues that need to be addressed. I think things are just being swept underneath the table.
And hence the interruption in our educational system, the interruptions in our police system, the law enforcement. It just won't change. And
Yeah.
these people, I don't want to refer to the Haitians as these people, but you know, they come and they serve their purpose for whomever they're serving the purpose at that time. And it's just so sad that they have to be the victim of circumstances. You know, it's just totally sad.
Yeah, if you would really step back and open your mind and don't be clouded, you would see that our whole economy, don't mind the chatter and the noise and the dancing and the partying and 50 years and this, but if you really step back and you notice that our whole country is just crumbling. The children are coming out of school. I went to Dunkin' Donuts, the woman came. The guy is punching the numbers on the computer, and pray God you give him the change that's close to what it is. He can't remember what the order is. It's like it's mind-boggling.
I was calculating myself, so that means y'all get y'all figures because I already have mine.
It's just something ain't right.
Yeah.
It's sad. It is sad. It is sad. And then we dumb it down further. You know, if they're not learning, okay, let's change the curriculum.
I mean, I thought these students would have been in school forever. To catch up for a whole 3 years. But they send them out to work and it's a sad state. And that's not the educational system.
And they come, they go back into school and then there's midterm for another year.
That doesn't make any sense.
No, it's so sad.
I mean,
Well, if we were at a D average when school was fully kept, I could only imagine what the average dropped to during COVID when they were supposed to be online learning and most of them were not there.
I don't want to know. I don't want to know.
Having an X and Tingham is okay.
Yeah. But it affects the country because every time you're trying to employ someone, it's very difficult.
You now become a statistic.
Exactly. So you're gonna have a lot of people in the next 3 to 5 years who are unemployed because they are unemployable.
And if you're unemployed, that means crime will increase
Exactly. Yep.
because they have to live.
Hold on.
Angry people, they angry at society. They feel society failed them.
Yes, and you're gonna have people committing crime, people committing suicide. It's gonna be a lot. We're gonna have a lot of social problems. Partying will also.
You know what it's going to be reminiscent of? The fallout of the drug era. You know how we always said that during the time it all seemed like glitz and glamour and everybody was living good, but we said on the downside of that, how, you know, and the Freeport is showing you the downside of that whole glamorous drug era.
Yeah. Yeah, it's a lot for you all to think about. Where are we going? I mean, even in terms of your children, if you have young children now in primary school or in high school, how can they afford a piece of property? How can they build a house? How?
They can't even afford to pay rent because they making minimum wage. So that means they got to live with somebody.
Yeah.
Live at home till they're 50.
But I mean, all of these things, this is at now at 50 years of independence, supposed to be a better way of life for Bahamians.
That's why a lot of people are saying that they are not excited about this celebration. They look at it as a farce and they think, you know, it's ridiculous because they're like, what are you actually? Yeah, we've made some strides, but we're not nowhere where we could have been if everything was being ran properly.
No, there's still potholes on the road. We still have to duck them. Why? Why do we have to do that? And I notice more and more persons are coming on the street with a little basket in their hand. Now, first is to put a cup. Now it's a basket in their hand, stretching out, asking for money.
That's right, a big minimum wage, I could tell you.
But the thing about it is, and it's not that the country isn't making the money. I got so annoyed when I heard the update on the budget, and they're bragging about the amount of taxes that they collected. And I try to understand if they realize you bragging about money that you took out of our pockets that we needed to do something else. And what did you do with that money? You went to Dubai and you all over the place talking about climate change and whatever the case may be, and not doing anything substantial for us. And you think that's something to brag about?
No one is accountable.
No.
No, the only person, people who can make them accountable is us, the citizens. And the thing about it is Bahamians are afraid to not go to work today and protest on Bay Street. Watch when you watch the foreign news. When you hear those people protest, it's not 10 and 15 people. They shut everything down.
Yeah, they unite.
They take over the White House.
Yeah, they take it over.
The thing it is, Ms. Archer, and I've always said this, we as a people do not stand together. Like, okay, I could be the martyr, okay? Just make me the martyr, but you ain't coming. Even in the workplace, you know, we
leave you hanging out high and dry.
You know, you bicker in your corners, and then when you, one brave soldier, go to represent all of us, nobody else has anything to say but you. And so you're looking like the donkey, you know? So that's just us.
Or they call you crazy, like how they call Lincoln crazy.
No, he on the verge. I see it in his face. Because he has a passion and he's fighting for a cause, and likewise, you know, the people are not standing, and so he get a little couple behind him, you know, and it's just so sad. We don't see the cost, we see the person.
Yeah.
Yeah.
There's a lot going on, and I just think it's being masked. It is showing, they're painting a picture that they want you to believe, and behind everything is deteriorating.
And it is, and the thing it is Ms. Archer, where I sit as an educator as well as a banker. You know, you could see it in the children's faces that they don't belong. And a man without a country, I said, it's a sad place to be. And so I feel like all of the crime and everything else, you know, it's just angry children acting out that they don't have anywhere. I don't belong to anywhere. you know, and so what do I do? Because some of my students, you know, are Haitian descent, and because they missed the mark of not being born before the independence. And so this country is all the country that they know, you know, and you find that they're now looking for jobs. I had a couple students of mine looking for a job. They find a job, we got to work under the counter as if they're not Bahamian citizens. And so they go and find some Bahamian or somebody who can open an account, and they use that account to get their monies, because now everything is becoming tech.
Yeah.
You know, got to be online and doing these things. And people are taking their monies from them because they're using their accounts. You know, that is so sad. That is
They-
just so sad.
You have to pay a fee to use the service, you see? And that's what Bahamians do all around. It's the same thing like the Shantytown. Everything they do, they have to be making some money from it, something from the side.
Beautiful, doing it side the tongue and doing everything else at the expense of people.
Yes.
You know,
Also the
at the expense
reputation
of people.
The
So,
jurisdiction.
and it allows to be and it allows to happen because it's a trickle down effect. Okay, so you go into the bank, the manager allow you to open this account, knowing full well why. You know what I mean? It's just because you're giving the manager a little tip too. It is just so sad. We just can't be say, boy, Bahamians like tip.
Yeah.
You know, but that's just, I don't know.
Internationally, they call us pirates.
That's what we are.
Yeah, they still call us pirates. Home of the pirates. Yeah, they do.
Ms. Archer, I really think like a well-organized protest, that you really understand what the quest is or what the fight is for. I think it would gather a larger crowd compared to what's been, because honestly, a lot of protests that take place on Bay Street, you just going by hearsay. This is what it's about, etc. Like you don't have a clear understanding as to what they are fighting for. So I think if people understand exactly what it is we're fighting for, like you're not just gonna go behind, let's just say, a Lincoln band carrying on, etc. Not as a professional or someone who's educated and who, you know, kind of look at things differently, you know, less emotional. So I think something well organized, you know what you're fighting for. I think the crowd will support it.
Like a Penland fight.
Right, but that has to be
something for real cause. Yeah.
But that has to be someone who the people believe
and respect
where they want to go.
And respect,
yeah,
too.
It's that respect, and that someone who, in the event, if they want to take over the government, not even wait for election time, but take it over like they do in other countries. It has to be someone who they respect, someone who can get the job done. That's why you see in a lot of countries, the ruler is changing constantly. People come before you, you tell them a story, you sing them a tune, and then they put you there and you don't do it, they tell you have to go. They're not gonna wait 5 years. They don't sit back and let it happen. You make promises, you better deliver. Because remember, they're spending our money. That VAT that they collect and any other expenses that you, taxes you pay, it's your money. They're spending your money. So how is your money being spent? That's the question. At the end of the day, you're spending all of this money. Where is my money going? I'm still dropping in potholes. The lights still are not working. The children still don't have proper education. Crime is high. You can't drive with your window down. Someone may shoot you. You can't cross the street. Someone may run a red light, knock you down. Where are the police officers? Where? Before you used to see them around every corner. You don't see them anymore.
That's because, Ms. Archer, they are doing other duties, engagement, private engagements, collecting money from the bank. No, private engagement. So you station them at the bank so the bank could get charged and they will split that money. Then you station them these other places where need security. And so the police is now becoming security. So their whole thing is about making extra money outside of their paycheck. So that's why you
It's
Sad though.
it's
Similar to the healthcare system. You can't call for an ambulance. You won't get it. You
No,
better
fine.
drive there yourself.
you ain't gonna get it. You ain't gonna get it. And then look at even though they talk about the healthcare system here in Grand Bahama since story, and we've been struggling. Well, and I saw too, you see it on the TV. You don't even want to go there.
Nope.
Sick as you is, you don't want to go to.
So let me point something out to you now. You see, you're talking about the hospitals. How long have we been talking about PMH? How long have we been talking about Iran? But in the papers today, they are talking about building 14 new airports in the Family Island. Which one take precedent?
Or
Okay then.
the ones that
Honestly,
we
I
give
was
them, they
wondering
cut.
why they were building a airport in Cat Island. Like right now, we have more pressing issues than to build another facility in Cat Island. Seriously, because they're just gonna start it and probably not finish it.
Yeah.
No,
Then it's gonna
you have
cost us
to
more
note
money
that
to repair it because it sits there so long.
They built a clinic. I remember I went to Exuma a couple of years back, a little while. But when I went to Exuma, I saw this beautiful clinic. And I asked the people there, I say, so when the clinic opened? Say, oh, they built it, but it was never open. I said, what?
that's what Abaco too. All of it is still
I was
not
just about to
open
say the
properly.
same thing happened in Abaco.
They don't have no people. They don't have no people to facilitate it in terms of nurses and no equipment. So it's there.
No.
I
Yeah.
really
And we have to note that with the airports, government's really not doing that. They got private people doing those things.
Mm,
And it might end up like a Grand Bahama where Hutchison came in, got their monies and gone.
yeah. And how does that help us?
yeah. We need a,
Not because we right there suffering in Grand Bahama.
yeah,
You
but
know,
we need some independent,
Yeah.
more so audit. I forget what they call it in the United States, the independent body that kind of keep an eye on, their senators, et cetera, and stuff like that.
Mhm.
Finance and make
So
sure they're
then,
paying their
what are you
taxes. What's the
talking-
name of that? Make sure
No.
they're paying their taxes and all of that.
No. You be
The IRS?
business. They'll tell you keep out of our business.
Yeah.
No,
That's what they'll tell you.
no, it will start a regular. It will start on a regular and then it becomes Bahamian. They all will get corrupt and we start right back over again.
Yeah, that's why we need an independent body to keep an eye on them.
Listen,
Who don't care,
you
people who don't
remember-
care who you are or who hip you kiss or whatever, they really don't care. They have a job to
that's
do
what I
and
said.
they do
will
it.
start out like that. It will start out like that, but we'll soon convert them. We've had judges who were good judges, and then they got corrupt. Because the system
The system.
is like that.
Yeah. You
And
need
it's really-
you need a clean slate, but you need the Bahamian people to say enough is enough.
I
And
think we're
that-
actually getting to that point.
Therein lies the problem.
Yeah, but you can't wait
Yeah.
5 years for that. Trust me, we will be broke. It won't be play broke. We'll be real broke.
But these new trend, this new generation will fix their business.
Yeah. Now,
Yeah.
we'll see. We'll see. All right. So I will hear from you all next week, Monday. I'll send you all some more cases.
Yes, ma'am.
Thank
Bye.
you.
Thank you.
Nice talk. Thank you all, guys. Good evening.
No problem. Okay. Good night.
Good night.